Today we are recording an oral history of Robert Ladd Delaney, a member of the Tennessee Bar for 48 years. His record, as you will see, covers a period of great development in Tennessee law. What's astounding to me is Bob's part in all of that, not through the legislative branch, but in the courts. So without wasting any more time, let's get started. Bob, where are you practicing now?
I'm at Instructor in White. I came over there in August of 2010, so I've been there for a while. They managed to let me stay, and I've really enjoyed it. It's been a good place to work, a very collegial group of people, as you know, and all quality practitioners and very ethical folks, and very likable folks as well.
Yeah, and I was there for part of that time.
You were indeed. Enjoyed it.
And I had a great experience with that firm too.
Yeah.
But let's don't get ahead of ourselves. Where'd you grow up?
Well, I grew up in Kingston, Tennessee, which is a small town about 30 miles west of Knoxville. Kingston is an interesting little town. It's the third oldest town in Tennessee. Jonesboro is the first oldest, and so Jonesboro is where everybody came into the state, and we skipped over. Kingston had an old fort there called Southwest Point, which was the southernmost point in the Southwest Territory. Of course, William Blount was the governor of the Southwest Territory before he was elected senator in Tennessee and impeached and all of that. So Kingston has an old courthouse there that's one of 7 or 8 pre-Civil War courthouses remaining in Tennessee. And I grew up in a house on the town square right across from the courthouse, probably, if it's not quite 50 yards, it's close. And my father was sheriff there, and my grandfather was a lawyer and clerk and master, and practiced there over the years. And
that was grandfather Ladd.
William B. Ladd, William Bartlett Ladd. Yes, he was. I never got to meet him. He died in February of '51, right before my first birthday. I guess I did meet him, but not so that I could remember anything much about it. And he had a really fine life and career there. The house that I grew up in was built in 1812 by a fellow by the name of Gideon Morgan, who had fought in the Revolutionary War and had gotten a land grant down there in Kingston. And he came down and he built this house, and it was licensed by the state of Tennessee as an ordinary, which meant that it was a place where you could spend the night and eat and so forth. It was kind of a, I don't know, boarding house kind of thing. I think that's probably the right word. And many famous people live there because, I mean, the route from west to Washington, D.C., for example, was right through there on what became Kingston Pike in Knoxville, and Andrew Jackson and various other famous people are reputed to have stayed there. The old ledger that people would sign in when they came in was stolen by somebody who was boarding in the house during the Second World War, and so we don't have that historical record anymore. But in any event, my grandfather refurbished that old house, which is in Homes and Gardens of Tennessee. And then he taught himself, well, he read law in a lawyer's office. Ultimately, he did a number of things before that. And then, as you and I have discussed before, some of the younger guys who were taking the bar exam at the same time he did, who'd graduated from the University of Tennessee College of Law, sort of made fun of him, didn't think he'd be able to pass the bar, but he did. And the first time he took it, and he practiced very successfully. As my dad said, during the Depression, he made money when there was no money to be made. And and became clerk and master. Judge John Jennings was the chancellor at that time, and ultimately, or was actually the circuit judge there. And if I'm not mistaken, a fellow by the name of last name was Carson was the chancellor. And so they made my grandfather the clerk and master. And he, back in those days, of course, there was no Bankruptcy Act, and the Chancery courts did all the receivership business that was to be done in the particular judicial districts that were, or the counties that were within the judicial circuit at that time. And so he had a farm out further on out north of his home downtown. There were peach orchards out there, and conflict of interest rules being more lax than they are today, he was able to acquire some of the surrounding peach orchards when they went broke during the Depression, and accumulated about 2,000 acres of property, which we now are developing up there. And we've got a town center and single family homes and commercial stuff and governmental buildings and all that. And so he's really the author of that feast. I mean, you know, he started all of that and was very successful practicing law as well as being the clerk and master. He had a great friend, excuse me, in Knoxville named Ray Jenkins, and they've tried a famous murder case together, which is chronicled in a book published by the East Tennessee Historical Society about Ray Jenkins' life and times, the terror of Tellico Plains. And of course, the defendant in that case came to my grandfather to represent him. My grandfather knew that he needed Ray's services, but Ray Jenkins knew that he needed my grandfather to help him pick the jury down there. And apparently they were pretty successful because of fairly brutal murder and sort of bad crime scene. So this fellow had killed his wife and cut her throat from ear to ear. Mm-hmm. But rather than being convicted of first-degree murder, and the state was seeking the death penalty, the jury came back with an involuntary manslaughter verdict, and he was sentenced to, the defendant was sentenced to 1129 in the county jail, and he was made a trustee the first day he was there, which means that they didn't keep him locked up much of the time, that he was out being able to work and not being back with the harder core inmates. And so, you know, that is just how he was. And you know, he invented a device that kept a Model T or Model A from flooding out on the, as you went across a creek back out in the country when you're delivering mail, and ended up testifying for Ford Motor Company in a big patent trial about that device in Chicago. He was a very active Republican Party member. He went to two Republican national conventions as a delegate. And when the time came, of course, the Republicans back in those days didn't have a strong hold on the state of Tennessee, which is sort of an understatement. And Senator Kenneth McKellar from Memphis, who was an Ed Crump protege, was getting older, and it was openly discussed that his health was poor, and it was thought that he would not be able to make it through the electoral process. And so the Republicans in East Tennessee, B. Carroll Reese, being the primary one up in Kingsport, Sullivan County, called my grandfather and asked him to run as for the nomination, the Republican Party for the United States Senate against McKellar in fall. And my grandfather won that election without opposition, and then went on to run against Senator McKellar. And as it turned out, the rumors of his, you know, untimely demise were exaggerated, and he survived, and my grandfather lost that race. But again, he was well enough thought of within the party that he was the guy that they turned to running that election. So he was quite a guy. I mean, he was the first person in our family that was involved in the legal business, and then
never went to law school.
Never went to law school, but again
that wasn't really unusual.
It was, and as you would know, I mean, people went to Cumberland Law School and were there for a year, and took the bar exam and passed, and so the formality of the educational process back in that period of time for lawyers was much less than it is today, and but he was successful. And then, of course, my father was sheriff there for 3 terms, 52 to 54, and then he got beat in 54, and then ran again in 56, and was there in 58. I may have mixed that up. Actually, I think he was 52 to 54, 56 to 58, then 58 to 60. He was there, and then in 60 to 62, we came down here to Nashville with him when he was in the Tennessee General Assembly, as what was called back in those days a flotorial representative, meaning that floated all over different counties. And so then after that, Dad was on the county commission up until the time of his death. He was a favorite of Judge Robert Taylor up in Knoxville. Judge Taylor wanted him to be the foreman of his grand jury up there all the time. And Dad finally had to tell Judge Taylor that he appreciated being that great honor, but he had to go back home to Roane County and make some money. And so he worked for the state of Tennessee for the final years of his life in the highway department. He was a material and test inspector. Then my mother, of course, was a school teacher, but she was much more than that. I mean, my mother was a very, very strong person, and a very bright person who nothing she couldn't do. Perhaps politically incorrect to say, but women in my mother's era sort of took a back seat to the men, but she didn't take a back seat in terms of intelligence or activity. She was always active in my dad's campaigns for various political offices. She loved it. She read and, was very interested in public affairs and what was going on, not only in this country, but others. And so she and my dad provided a strong background for my sister and I. And then, of course, now I've become a lawyer, and for 48 years, as you said, and my youngest son is in his final semester of law school at the University of Illinois, he's going to be an Order of Coy graduate. He is executive editor of the Law Review. He's active in special moot court programs and has won, the best oral advocate in some of the competitions and best brief writer and all that sort of thing. So 4 generations of legal activities in my family, and hopefully there will be more than that. It seems like the laws are.
Ask you one question before we leave Kingston, before you grow up and graduate from high school. It was capital of Tennessee one day, wasn't it?
It was. I mean, the Cherokee, again, we talked about Fort Southwest Point, and that area was a principal trading area for the Cherokees. So the white settlers wanted some, pretty good territory that the Cherokees possessed. And so whoever the leader of the Cherokees were, they said, well, we'll give you that if you will make Kingston the capital of the state. And so at that time, Knoxville was the capital. The legislature said, we'll do that. And the governor said, we'll do that. And so the legislature convened and passed a bill to move the capital of the state of Tennessee to Kingston. And they reconvened the next day down in Kingston, and a new bill was introduced to moved the capital back to Knoxville, and so that's Kingston being the capital for a day. So I guess I wanted to live in the capital, and I moved to Nashville.
Yeah. Well, now, when your father was in the legislature was not paid very well. Did your father do anything to supplement his income?
He did. I mean, at the time, I mean, you're exactly right. I mean, you know, you got a per diem, or Dad would either stay at the Hermitage or the Andrew Jackson for the most part. And of course, Nashville was very different back then. I had dinner Saturday night, last Saturday night at the Hermitage Hotel. And of course, they've redone it all. But back in Dad's era here in Nashville, it was all white tablecloths, starched white tablecloths and white napkins and all that kind of thing. And, you know, after working hard all day, the legislators needed to have some recreation. And there was a high stakes poker game that everybody played in. And Dad was a great poker player. And he always supplemented his income while he was down here playing poker. And of course, printers out, no liquor by the drink. A fellow by the name of Harry Beniza had a whiskey store in the front part of the Hermitage Hotel. And then, of course, Printers Alley was active and open. So late nights in Printers Alley would stay. And then if it got really late, there was a place over on First Avenue called Malone's that all the legislators went to. And they had, you know, steaks and country ham, and the food was really good. And Nashville, of course, was a much smaller town back in that time.
Yeah. So your first involvement with the law was, I guess, your grandfather died before you were born, but it was his legacy that you kind of grew up with. And then your dad got involved, and I suspect you witnessed a lot of what was going on in the law when you were growing up.
Well, as I said, you know, I mean, the courthouse was at most 50 yards across from the front door of our house. And sort of one of the political prerequisites of being the sheriff was that you were the chief courtroom deputy during the trial of criminal cases. I mean, prisoners, of course, had to be brought over from the jail, and that was a short walk from this old jail in the back, but there was always a security issue with that. And so the sheriff was always in the courtroom, and the July term of court in Roane County was the criminal term of court. And so Dad was in the courtroom. I was right across the street. I'd be in the courtroom watching the lawyers try the cases. And of course, back in those days, no air conditioning there. And when I was really just a kid in the mid 50s on up to the 60s. And so I'd go over and watch it. Of course, the lawyers would take off their coats and, you know, roll up their shirt sleeves and try the cases. Dad would be there as sort of the bailiff and coordinating the security. And then, of course, the jail was right in the back. And every Sunday, Dad had a wonderful cook over there named Margaret McAnally, who not only cooked for his staff, but also for the prisoners. They were pretty doggone well fed. And we'd go over after church on Sunday and eat, you know, dinner or lunch at the jail. So it wasn't exactly Opie in Kingston, wasn't Mayberry, but it was sort of some of the same dynamics.
Yeah. Is that when you decided you'd like to be a lawyer?
Yes. I mean, I decided fairly early on that that's what I was going to do. I mean, I remember playing with my grandfather's briefcase and law books and things like that as a kid. And then what really, you know, actually cinched it up, when Dad was in the legislature, he allowed he got metal folding chairs and put by either side of his desk on the floor of the House of Representatives here. And my sister and I got to sit on the floor with him. And there was a very prominent Democratic member of the House of Representatives at that time. As a matter of fact, I think he was either majority leader in the House or the Speaker, and he was both at different times. I can't remember which time this one was, but there was a fellow from West Tennessee who you would know very well named Dick Berry, who was an incredibly effective man. He was I found out that he was a lawyer, and I found out that he'd gone to Vanderbilt Law School. And I watched him I was a small boy in operation. And I thought, man, you know, the way he does and what he accomplishes is really something that would be a good way to spend your life. And so I decided at some fairly early point I was going to be a lawyer, and I wanted to get down here to law school.
Were there any other boys you grew up with that turned out to be lawyers?
There were. I mean, of course, Jack Seaman was about 4 years older than me. Jack became a lawyer. And of course, Jack, 4 years difference in age when you're really young is like, you know, a big deal. They're the grown-ups and you're not. And of course, Jack played high school football in Kingston just like I did. And he was a guard on the football team, and I was guard on the football team. And much to my surprise, and we're getting ahead perhaps just a little bit, but when I went to work in the Tennessee Attorney General's office, Jack's office was right next to mine. And so I got to work with this guy who'd been one of the big folks when I was growing up. And that was great because he, as you know, he was a wonderful fellow. And then the other guy who practiced law here that I grew up with was Dan Worley. Dan's sister and I dated in high school, and I spent more time out at the Worley's house my, you know, junior and senior year in high school than I did at my own house. And I thought the world of Dan. He was very effective. You know, he was a great litigator, a good guy. And sadly, both Jack and Dan have passed away. I guess I'm still glad to be here. I mean, Dan was just a couple of years older than me. As a matter of fact, was over at Tune Intricate in a mediation about a month before he died. And his sister wised up and decided to marry somebody else besides me. And she went to Duke, and she became the chairman of the Department of Economics at Notre Dame, PhD. Worked for Juanita Krebs in Washington, D.C., who was Jimmy Carter's Secretary of Commerce and a former professor down at Duke. And so fine folks, fine family.
Yeah. Well, you mentioned playing football in the high school. That was in Kingston, I take it.
It was Roane County High School. I graduated from Roane County High School in 1968 and played football and was active in student government, and they voted me most likely to succeed. I'm not sure that they got that one right, but in any event, I was there. And you know, and Kingston was a small town. You know, when my grandfather was there early on, and my mom and her brother, who was a doctor, Hugh Ladd, you know, Kingston had a population of about 500. You know, by the time that I came around, of course, Oak Ridge and TVA had swelled the population significantly. And but it was a good small town to grow up in. We considered Knoxville the big town to go to. But, you know, given my family background, we found ourselves down here in Nashville frequently. And I think that's one of the things that ultimately made me want to come back down here.
Okay, so you graduated from high school in 1968 and went off to Carson Newman.
Carson Newman College, small Baptist school in Jefferson City, Tennessee. My uncle, Hugh Ladd, had graduated from there at some earlier point and then went on to medical school down in Memphis. And my mother was at Carson Newman for a year or two and then transferred to the University of Tennessee. So there was some family connection. I guess that was really the reason we decided. My sister and I both went there. And, you know, I was tried to be active in everything that I could be up there. I was a political science and history major, and the history and political science department were considered fairly liberal. I mean, I started up there in the fall of '68, graduated in '72, and you'll remember the political climate at the time. I mean, you had the moral majority starting, and there was the debate about Engel versus Batali, prayer in schools, and all those sorts of issues were really hot button issues politically during that period of time. And so I ran for student government president up there when I was a sophomore, got beat in a runoff by about 50 or 60 votes, ran again the next year and was elected. And one of the things that the student government president got to do was to pick speakers for a big symposium that was held every year. And the two people that I picked for that symposium were Albert Gore Sr. And a fellow by the name of Reed Buckley, who was Bill Buckley's brother, and who had a conservative political think tank down in South Carolina. And obviously the idea was that you'd have a more liberal political view, and then you'd have a more conservative political view, which was a very rational, coherent political view. And so John Fincher was the president of Carson, and there were those constituents and contributors to the college who basically didn't think that Gore Sr. was a good person to have come speak there.
Old Republican East Tennessee.
Absolutely. And so they tried to squash that, and Dr. Fincher, in my opinion, to his great credit, said, no, he's coming. He's a very credible person, and we need to have a broad view of things, and he's going to give his view, and then we're going to have this conservative view. So Senator Gore, of course, had just been beat by Bill Brock in 1970 for the United States Senate, and so this was in 71 when he came, if I remember correctly, fall of 71. And so he got up and he started out his speech by saying, you may have seen that I was recently defeated for the United States Senate. And on election night, I was talking to my wife, Pauline, about that. And she said, well, Albert, it may be a blessing in disguise. And he said, I told Pauline if it was a blessing in disguise, it was damn well disguised. So that was that. And then, it was on after that to get ready and go to law school. And
did you play any sports in high school?
I played football
in college.
No, I didn't. I mean, I was a pretty good high school football player. I think. I don't know whether people would agree or not with that, but I never was really big enough to play college sports. And in retrospect, I'm glad I probably didn't, because I'd be banged up more than I already am. So yeah.
Okay. You graduated from high school in 1975.
No, 68.
68.
68.
I mean,
68.
College in 1970.
No, I graduated from college in 72. And then I came on down here to Vanderbilt. I graduated from law school in 75.
I got you.
Yeah. So, yeah, I mean, I came down to Vanderbilt Law School. It was a challenge for me because the background and the whole dynamics of the school were very different than anything I was accustomed to. Basically, at that time, Vanderbilt was considered to be a very strong regional school. And the other two strong regional schools were Duke and Emory. And what you found was if aspiring lawyers didn't make the cut at the Ivy League schools, then the next step down were these strong regional schools in North Carolina, Georgia, and Tennessee. And of course, John Wade had been the longtime dean and reporter for the Restatement of Torts, and he was getting older. There was another professor who was like the Kingsfield of Vanderbilt, Paul Hartman, who taught contracts. And I'll have to digress for a minute and tell a Hartman story. I mean, first class I went to in law school was Professor Hartman's contracts class, and Hartman would torture you with the seating chart. You know, he'd start at the front, go to the back and forth, and nobody ever knew who was going to be called on. And finally, in that first class, the first guy he called on was a fellow by the name of Bob White. And Bob had gone to Duke undergraduate school, and he had been a Marine fighter pilot in Vietnam for a while. And he, wonderful guy, closely cropped red hair, you know, with some military bearing. And Mr. Hartman stood him up and he said, "Mr. White, tell us about this case." And Bob said, well, there were these guys, and all of a sudden this fairly short fellow down on the, you know, podium down below just exploded. And he said, "Mr. White, this is not a GD Broadway play. This is a lawsuit. It is plaintiff and defendant." Well, you know, and Bob, who had fought, you know, in air fights, you know, got red as a beet, and it really affected him. So I knew that I had gotten into a little different environment than I had been accustomed to with that. And so, you know, but I made it through okay. And we had a new dean the first year. His name was Bob Knaus. He'd been at the University of Michigan. And the folks at Vanderbilt brought Dean Knaus in with an eye toward making Vanderbilt a national law school. And the class of 1975, which was the centennial class of the law school and the university, was recruited from all 50 states. I mean, we had folks from Hawaii and other places. I mean, in a class or two earlier, Bill Koch, who you would know very well, had grown up in Hawaii. So we had people from all over the country, many of whom had gone to Ivy League schools. And so it was a different culture than I had experienced before. I was really lucky. I got in, we had 6 academic courses the first semester. And then we wrote various types of letters and memos and things like that. And I was in Bob Knaus's writing group. And so, you know, I got pretty close. We had a close relationship. And my wife at the time and I spent Christmas taking care of his house one year. And then, of course, you know, later on, I did my 3rd year writing paper for Hal Levinson, who, as you would know, taught administrative law, among other things there. And as I understand it, was one of the folks who was mover and shaker for the passage of the Uniform Administrative Procedures Act in Tennessee. And of course, Junius Allison was the first director of the clinical program at Vanderbilt Law School. And Junius Allison had been the director of the National Legal Aid and Defender Fund for many years, and had been in Washington and Chicago, and had worked closely with the ABA, and really was the one of the principal authors of the Legal Services Corporation Act. And Mr. Allison had gone to Maryville College and University of North Carolina Law School. And so in many ways, his background and my background were the same. And so, of course, Hal Bigham, who you would know, taught civil procedure there. And I took his trial practice course and did the best in that course that year. And Hal introduced me when I passed the bar at Tennessee Supreme Court. And then, of course, he went out and taught for many years at Pepperdine, and it's now back in Nashville, I understand. So, a great group of people, a challenging period of time for me. Learned a lot. And in the summer of '74, I worked in a program in the district attorney's office here, sort of a summer assistant. And that was the summer that where Tom Shriver was the attorney general here in Tennessee, district attorney general. And as we were talking before we started this recording, I mean, General Shriver was one of the last district attorneys in Davidson County who regularly tried cases himself. And of course, that shortly before that, one of the country music luminaries, String Bean, and his wife Estelle had been murdered by John Brown and Doug Brown, and there was one other person involved in that. And so that trial came on to be heard in the summer. Well, part of it in the summer of '74. There was Arnold Peoples represented John Brown. If I remember correctly, Joe Binkley Sr. represented Doug Brown. And I don't remember who the third defendant or lawyer was. David Pack also worked with Arnold Peoples in that case. David Pack had been the Attorney General of Tennessee, originally from Sevier County. He had left the Attorney General's office and was in private practice. And of course, Arnold, as you would know, had worked for General Pack, and I'm sure they were close to each other. And so David Pack helped out with the trial of that case. And the debate initially after the insanity defense was asserted for John Brown was whether the guilt phase or the sanity phase would be tried first. I did the legal research for General Shriver on that issue, and it appeared to me from what I had come up with that the guilt phase should have been tried first. Judge Cornelius, Alan Cornelius, was the Division III criminal judge here in Davidson County at the time. He didn't agree with us about that. And so in the summer of '74, the sanity phase of the String Bean case was tried as it related to John Brown. He was ultimately found to be sane. General Shriver, as we also discussed before this, argued in part to the jury, he's not crazy, he's just me. And the jury decided that he was not crazy, but he was just me. And so then moved on to the guilt phase. So that was, that again was summer of '74. That
was your junior year at law school?
Well, that was right at the end of my second year, yeah. And then I started in the fall of '71, I started back to my third year in law school. And actually the other thing that I did that summer that I probably should mention was Hal Levinson, who I just had the highest regard for, was teaching a kind of a seminar on state constitutional law. I mean, the character of the United States Supreme Court was changing. We were moving out of the warm court era and into a more conservative court. And there were a lot of legal thinkers back during that period of time who thought state constitutions provided a basis for courts to grant broader rights to citizens, and that you should study the state constitutions and try to persuade courts to rule on state constitutional grounds rather than federal constitutional grounds. And so Mr. Levinson was a proponent of that, and I ended up doing my senior paper on the issue of the use of state constitutions to grant broader rights to citizens and criminal defendants and others in various ways. And as it turned out, that had a real impact on some things that I subsequently did in my career. And so I always think of that. And then the other story I guess I should tell is the next to the last examination I took in law school was taxation of estates and trusts, Herman Troutman. And I had about as much business taking that course as trying to be an astronaut. But in any event, after I finished up that exam, I came out and one of my other professors named Jerry Black was standing with his back to this glass area in the middle of in an atrium in the law school, which we call Black Ape. And he motioned me over, and I'd had a class with Jerry that semester too. And the only reason I could think of that being the insecure fellow that I am, that Jerry would be there is to tell me I had not done well on his exam. But as it turned out, he had been up talking to Dean Canals, and the dean basically said to him when Jerry told him he was going to become a visiting professor for 2 years at UT Law School, why don't you see if Bob Delaney would like to take your position for a couple of years? And so he was there to ask me if I'd do that. And I was just astonished. I mean, I never thought about doing anything except going back to East Tennessee and practicing law in Kingston or Knoxville or both. And so I said, well, wow, I don't know what to say. And so there was an old Meeting 3 across the way at the time that the McFarlands owned called Max. And Jerry, who was a big beer drinker and pinball player, said, why don't we go over, we'll drink a beer and play the pinball machine at Max, and you can decide while we're doing all that. And so, of course, I said yes, ultimately. And so after I graduated from Vanderbilt in May of 75, I started as an instructor in the clinical program. And of course, Junius Allison was the director at Still. And I have to say that, and other people unfortunately have different experiences, but I've had, some of the best mentors in my life have been the people that I came in contact with in these various employment positions. And Junius certainly was the first one.
So was the clinical program in Vanderbilt fairly new?
Very new. There was a real reluctance at Vanderbilt to start a clinical program.
There had been one at UT for a long time.
There had been. And it was a great one, of course. Harvard had the first one. UT came along pretty shortly after Harvard. Generally, the theory was that, law school was a place to, hone your academic skills, and that was the way to fashion the best lawyers, as opposed to engaging in any kind of practical kind of pursuits. And so the trend was really had been against clinical education for a long time. But Vanderbilt, again, was in the mode of becoming a national law school as opposed to a strong regional school. And they realized that in order to achieve that national goal, that they had to have clinical programs. And so they picked an exceptionally qualified guy, credential-wise and otherwise, to be their first director of the clinical program. And as I said, Junius's background and mine had some similarity to it. So, I started working with him, which he was very capable and very ethical. And so I was there for a year. During that year, he asked me if I wanted, Junius Allison asked me if I wanted to get an LLM at Georgetown. He said, I've got good connections to I can't remember, I think it was the Ford Foundation. And he said, they would be happy to pay for your couple of years at Georgetown. And I will have to say, this is the only decision in my career that I've made that I really regretted. I said, Junius, really, I don't want to practice law. I don't think I want to go 2 more years of school. And so I turned him down on that. Primarily what the clinic, of course, you had indigent folks that we represented through the clinic, but then in addition to that, we had a grant from, again, I think it was the Ford Foundation, for the representation of students at all the colleges and universities in Nashville, regardless of their economic circumstances. So again, having grown up and seen criminal cases tried, I thought I wanted to do a lot of criminal work. And the first criminal case that I got, had a student who was getting a library science degree from Peabody College, and had another one who was getting a master's degree in English from Vanderbilt. And they, being young guys who do not smart things, got out one night in a Metro park and had consumed a fair amount of vodka, which the unconsumed bottle, a portion was in the bottle, was left in their car. And they decided it was a summer night. They decided it'd be great if they just sort of, cruised the park or mooned the park or whatever. So they took off their clothes and were riding through the park without any clothes on. Well, next thing you know, the park police catch them, and they're charged with indecent exposure and possession of alcohol in the Metro Park. Needless to say, a conviction for either of those offenses would not have been helpful for a librarian or for an English teacher. And so I got the case. And Claudia Bonnyman was assistant district attorney to begin with. And they were charged on Metro warrants as opposed to state warrants. And so the goal, they didn't have any clothes on, and they did have a bottle with some unconsumed vodka in it. So there wasn't a great chance of a successful defense to that. So Claudia and I got our heads together, and we decided to get rid of the Metro warrants and convert them into state warrants. And we ended up with pretrial diversion and expungement with that. And so that was my first criminal experience.
Well, I was going to observe that it's been my experience, I think, that these clinical programs really do provide a great service. And the students who get to participate in that accomplish some amazing things. It's stunning almost. So I think that's my view of how they work.
Well, I think it gives folks a practical dimension, to what they're learning in the classroom. And of course, one of our federal magistrates now is a former clinical professor at Vanderbilt. And that program has, expanded and done so well. But the primary function, we represented individuals ourselves, but truthfully, the primary role was to let the student do the trial of the matter and the preparation of the matter. And my role was predominantly as a supervisor of that process. And of course, I hadn't had any real experience either. So, it was a matter of learning on my own. There was a multi-volume loose leaf trial practice manual called Goldstein and Lane on trial techniques that I got and I used all the time. And then, as I mentioned to you before, I hadn't drafted a civil complaint before. And so I went down to legal services from small office at that point, Ashley Wilcher and Walter Kurtz and Dave Tarpley and Gordon Bonnyman. That was the core of the office. And I think in this particular instance, I think it was a complaint that Walt had drafted and used in federal court. And I took that as a model for the first civil case that I ever tried, which, as you know, was the Yvonne Gray case.
Well, let me stop you before we get into that. And I want to just get you to recite your employment record from start to finish. You started in the clinic.
Started in the clinic for 1 year, and had the chance to be there for another year. But as it turned out, Walter Kurtz had gone up to UT to become the head of the criminal section of the clinical program at the UT Law School. And Jerry Black was up there, and another Vanderbilt graduate named Dean Rifkin was up there. And so I had always, hadn't thought of anything else except going back to East Tennessee to practice law. And so they were kind of interested in me coming up there, and I was interested in coming up there. And so I told Junius, I said, look, Junius Allison, I said, if this won't hurt your feelings or make you mad or be disappointed with me, I'd really like to go up to Knoxville for the academic year 76, 77. So in September of 76, I left Nashville and went to Knoxville and was in the clinical program at UT Law School in the criminal division for a year. And then after that, I came back to Nashville. And from September of 77 until May of 79, I was in the Tennessee Attorney General's office. Started out in the criminal division and remained in the criminal division, but also did some civil trial work on a big matter. And then in the course of working in the Attorney General's office, I met Bill Willis. He was representing Murray Henderson, who at the time you'll recall was the Commissioner of Correction in Tennessee in a 1983 case. And I met Bill for the first time at the offices of Willis and Knight, which at that time were in the General Counsel's office of the old National Life building. And Bill and I got to know each other, and I was, really attracted to Bill, very fine lawyer. And so I went to work for Bill and Al in May of 79.
Well, let me back you up to the time you were in the AG's office. Who else was there? A lot of names that we would recognize, I'm sure.
Well, of course, Brooks McLemore was the Attorney General from Jackson, Tennessee. General McLemore had been a chancellor in Madison County, and then he'd also been in the state Senate, and then he had been executive secretary of the Tennessee Supreme Court, and then became Attorney General. And Brooks McLemore was just, again, in terms of my earlier comment about mentors, you couldn't have found a better one than General McLemore. And then the other one who was just great, who I was very close to, was Hayes Cooney. Hayes was the chief deputy attorney general at that time. And Hayes was a wonderful guy, conservative Nashvilleian who, from pretty good economic circumstances, who had gone to Vanderbilt Law School and who had worked briefly at the Cornelius Collins firm, and then went to the Attorney General's office and was there for many years. I mean, Hayes was an amazing guy, as you certainly know. I mean, of course, back in those days, there weren't nearly as many people in that office. We were down at 450 James Robertson Parkway, and there was like the first floor, which was the Attorney General's office and Hayes's office and some offices in the back and the library. And then the second and the third floor were for the assistants. There were about 30 or 35 of us. And people like Joe Haynes, who became United States District Judge, was in the office at the time. We already talked about Jack Seaman, David Raven, Mike Passeno, my subsequent law partner and friend Knoxville, came in for a while, Bob Tucker, who I'd worked with in the clinical program in Knoxville, was there as well. And so there were just really some fine lawyers, and it was again a pretty collegial group of people, and very little bureaucracy compared to what I'm sure it is today. So small, close knit group of people,
and a very valuable experience, I'm sure.
Oh, no question. I mean, because we were all pretty young. I mean, gosh, when I started in that office, I was 27 years old. But when you walked into a courtroom representing the state of Tennessee, the level of credibility was much higher than an ordinary 27-year-old lawyer in Tennessee. But it was a great group of people. We did, 3 criminal briefs a week, or we got assigned 3 criminal briefs a week. We also got a 1983 response and a 2254-5 response. And then in addition to that, we had legal opinions that we were supposed to on various legal issues that were either requested from the legislature or some agency of state government to write. And the opinion of the Attorney General, of course, was not controlling, but it was highly persuasive. And so it was something that you really had to work on. And so we didn't have any spare time there. And so I remember so well, I usually got to the office like 8 or 8:30 in the morning, which I thought was pretty respectable appearance time. And so one morning I came in about that time, and the Attorney General was sitting in my office, and I'm thinking, oh my gosh, what is this? And so I came in, and General McLemore said, well, he said, have you ever drafted any legislation? And I said, well, no, sir, I don't think I have. He said, well, would you be willing to try it? I said, yeah, sure, I'd be happy to take it on. And of course, what had happened was that the Court of Criminal Appeals had decided that the manner in which Wilson County and the other counties in that judicial district issued search warrants and arrest warrants was unconstitutional. They had folks out there who got a fee when they issued a warrant, search warrant or arrest warrant, but didn't get a fee when they didn't. And of course, the United States Supreme Court, in a case called Conley versus Georgia, had decided you couldn't do that you couldn't be neutral and detached if you got a fee when you issued one, but you didn't get anything if you didn't issue. And so a state senator from out there at the time named Bill Baird was on General McLemore like a duck on a June bug. I mean, they had served together in the Tennessee Senate and were friends, but Senator Baird, every time McLemore did something that displeased him, was threatening to move the Attorney General's office to Watertown. And so in any event, I drafted this legislation, and it called for the creation of a new position in Tennessee called judicial commissioners. And so the bill, I can't remember whether, I guess probably Senator Baird introduced it first into the Senate, and then there was a House sponsor as well. And so back in those days, technology, of course, was much different than it is today. And, General McLemore had a telephone on his desk with buttons and, something that you could, a speaker box. And then in addition to that, he had a speaker box on his desk so that he could hear the deliberations that were going on in the House and the Senate up on the Hill. And so, Senator Baird was just in a sweat to get this thing passed. And so I was in the Attorney General's office one day when Senator Baird was on the speakerphone, and General McLemore and Hayes were there as well talking. And Senator Baird said, Brooks, he said, you need to come up here and make a speech in favor of this bill. And these are quotes. I remember this just like it happened yesterday. General McLemore said, now, Bill, I'm not going to do that. And Senator Baird then said, well, send that boy up here. And I was the boy, and I was 27 years old. So General McLemore sent me up there. And, you know, with a fair amount of trepidation, I think the only non-member who prior to that who had made a speech on the Senate floor was John Wade with respect to some tort reform stuff, comparative negligence issues and that kind of thing. So I go up there and I get some questions and the questions that are phrased in a way that I don't want to answer yes. And so I have to say, well, respectfully, I don't quite agree with that, and I make a speech and bill gets passed and everybody's happy. And I have a real experience. I mean, so just apropos of your earlier comment, I mean, the experiences that you got as a young lawyer, I mean, we were arguing cases in the Sixth Circuit all the time and in the district courts and in the state courts. I mean, another favorite story from that period, Houston County passed a wheel tax and nobody in Houston County was in favor of the wheel tax. And so somebody quickly challenged the constitutionality of the wheel tax. Bill Peeler was the county attorney for Houston County at the time, a very fine lawyer down in Waverly, as you would know. And so Judge Spencer had been the judge down in that judicial district or in circuit at the time. And he had retired, and Leonard Martin had been appointed by Governor Blanton to take his place. And apparently the docket was a little bit, Chancery docket was a little bit behind in Houston County. So Judge Martin was holding court down there on Saturdays. And so our case was appropriate to be decided as a matter of law. And he set us to be heard on Saturday morning. So I drove to Waverly and Bill Peeler and I then drove up to Erin, which is a pretty good drive from there. And we were to argue the constitutionality of the Houston County wheel tax. I, being young and naive, thought there wouldn't be anybody in the courthouse except the judge and the lawyers. Well, that was totally wrong. I mean, people in Houston County were really interested. I mean, it was a standing room only crowd. So I kind of leaned over to Peeler and I said, Bill, I said, I think you and I are about the only two people here who are here in favor of the constitutionality of the statute. And I said, we're getting paid to be up here, And so then we argue it. And I, again, being young and naive, think that Judge Martin will take the matter under advisement, but he ruled from the bench that morning that it was constitutional. So again, you got to have experiences like that as you.
Yeah, and those country courthouses, anytime the court met, there was always a crowd.
Right. And it's kind of still that way down in Cheatham County. I mean, people actually like to come and listen to the lawyers argue the cases, and they take sides. And so it was a real experience.
Yeah. Well, you mentioned started into another phase of your career, and that was while you were with Willis and Knight.
Right, Willis and Knight. I was there.
Big, great lawyer.
Oh, no question about it. I mean, Bill Willis had grown up in Sumner County. His mama was a school teacher, and Bill went to Tennessee State Teachers College, I think it was called at the time, before it became MTSU. And then went to Vanderbilt Law School. Bill, if I remember correctly, was in the class of 54. He and Judge Tom Wiseman were in the same class. And then Bill went into the service during the Korean War era. He and Tom Higgins came out and formed the great law firm of Higgins and Willis, or Willis and Higgins, probably, I don't know which, and they were in the Life and Casualty building, and they were starving to death. Higgins had a family. Willis was not married at the time. And this is Bill's story. I can't vouch for it independently, but apparently some younger lawyers had left established firms in Nashville and taken business with them. And one morning at breakfast, some of the barons at the bar got together and they said, well, if they're going to do us like that, we just won't hire anybody. And Cornelius and Collins was one of the firms that had the embargo on hiring. but they had too much work to do in order not to have some extra help. And so they started independently contracting cases out to various lawyers, and Willis and Higgins were two of the lawyers that they contracted with. At some point, Tom, again, still starving to death and trying to feed a family, had to come in and tell Willis that he, after the embargo was lifted, that he was going to go to work at Cornelius and Collins. And of course, we both know that he became a named partner in that firm and then became United States District Judge. Willis went on to practice with John J. Hooker and his brother Henry.
Hooker and Willis.
Hooker and Willis. That's exactly right. I mean, John J. told me that he was impressed with Willis's courtroom ability. He had seen him try cases, and there was a certain amount of chemistry there, and so they formed a firm. And that building that they were in, it was where the median is between the Stallman building and the courthouse. It's obviously been torn down a number of years ago, but that's where their office was initially. John Jay, of course, went on to be a Democratic nominee in '66. Democratic candidate for the nomination in '66 for governor of Tennessee, and was defeated, and then became the Democratic nominee in '70 and was defeated in the general election by Winfield Dunn. But Bill Willis was his campaign manager each of those times. Judge Gilbert Merritt was the treasurer in both of those elections. Judge Merritt was the younger of all of them. Willis used to say that the treasurer was the one who always got into federal criminal trouble. And since Merritt was younger than any of the rest of them, they thought he should be the treasurer because he would have an easier time in the penitentiary. That's a quote. But needless to say, I mean, Judge Merritt never did anything that would have, no pun intended, merited him going to the federal penitentiary. But in any event, that was sort of the humor of that group. And so then, of course, John Jay went on to chicken business and various other, business kind of ventures. And Willis when I first knew about that firm, it was Willis and Knight and Barr. Bill Barr was the other partner. By the time 1979 came around, it was just Willis and Knight. And Al Knight was a brilliant lawyer. He and Gil Merritt were classmates at Vanderbilt. They went to Harvard and got an LLM together. And of course, the Hooker and Willis firm had represented the Tennessean for many years. Amon Evans and John Jay were close, and the Tennessean had supported John Jay in his campaigns for governor. So that was a significant client for that firm to have. After John Jay left the firm, Bill and Al continued to represent the newspaper, and actually the Tennessean was sold in 1979, just shortly before I think it was 79. It could have been 78, but I think it was in 79, just right before I came to Gannett. And John Siegenthaler, who was also an extraordinary person, who we all know had worked as assistant for Senate Attorney General Robert Kennedy, and was very close to the Kennedy family, was the editor and ultimately the publisher of that newspaper. And of course, the Tennessean was an incredible newspaper. I mean, in terms of some of the work, it wasn't the New York Times, obviously, in the sense that it didn't have the money and the circulation. But on the other hand, it was one of the outstanding newspapers in the country, and everybody knew it. And many of the best journalists in the country at the time had worked for a time. David Halberstam, for example, at the Tennessean, and so it was just a powerhouse. And so Al Knight was the guy who principally on a day-to-day basis gave editorial advice to the Tennessean. and you know, was well regarded in legal circles around the country as being you know, outstanding First Amendment lawyer, and of course he was a good lawyer at anything that he did. He was a powerful, very intellectual guy. So it was a great law firm to go to work for. There had been many fine lawyers who had been associated with that firm over the years. It was close to the political pulse of Nashville and the state and the country. I mean, Bill, during Governor Blanton's administration, was appointed chairman of the Appellate Court Nominating Commission, and again, as you would know, not only did that commission recommend 3 folks to the governor for appointment to appellate positions, but in addition to that, it recommended trial judges when there was a vacancy in the courts. And so Bill Willis's hand was on all of those things. He had, and to the extent that he had an opinion, and John Siegenthaler had an opinion, and Gil Merritt had an opinion, and Jim Neal had an opinion about, you know, who ought to be the appointee. The governor, not having much judicial background at that time, would, you know, defer to pretty much who they wanted to pick. And you know, I mean, I would respectfully suggest that some of the finest judges that I've appeared before in the state of Tennessee during that time were the folks that they had selected. And then, of course, in addition to all that, Bill was chairman of the Board of Professional Responsibility for some time during that period, and president of the Nashville Bar. And I don't know how he ever had time to sleep between his law practice and his other duties.
Well, let me tell you, backing up to the time of Higgins and Willis, I guess it was, wasn't it?
I think it was.
Tom told me years later about how tough it was. Then on Saturday, trying to pay their secretary for their week's work, they had to empty their pockets, and a lot of her pay came in nickels and quarters.
Yeah,
they were really struggling back then.
Well, and during the Hooker campaigns, I mean, they weren't practicing law much. They were running for office, so they weren't making any money. And Christmas after John Jay, I don't remember whether this was in 66 or 70, but in any event, the Christmas afterwards was very sparse. And so they all literally collected their change and had the Cratchit luncheon at Borello's and paid Frank and Eva with change. So, top flight lawyers in the city, but they just, starting out was hard, and their extracurricular activities, took them away from the law practice.
Yeah.
So it was slim.
Well, let me tell you a story of John Siegenthaler. I was appointed by Governor Dunn to the Chancery Court in 1973. I had to run again in 74. And it was a tough uphill climb for any Republicans elected to countywide race. And I wasn't smart enough, I guess, to call the Tennessean. But one day the phone rang in my office, and it was John. And he said, "You haven't asked for our help, but we'll be glad to do anything we can." Now, a lot of that was the quality of my opponent, and none of the Democrats wanted him as a trial judge, and that was, but you don't find people like that really often.
You don't.
I just think it's one of my great memories of John Siegenthaler.
Well, I'll tell you 2 quick stories to demonstrate my memory of him. Actually, 3. One, first time I ever met John Siegenthaler, I knew who he was, but first time I ever met him I had been at Willis and Knight for 3 days, and I was in a little windowless office on the 3rd floor of that building between Bill's office and Al's office. And Bill called me on the intercom and said, I want you to come down to my office. And I said, okay, I'll be right there. And when I stepped out of my office and walked toward his, I saw that his door was shut. And that was very unusual. Bill was not a closed door kind of guy. So I went down and knocked on the door, and there were 4 people in the room. Bill was at his desk. A heavy-set guy in overalls and brogans who looked like he'd just been out in the field plowing was sitting in Willis's rocking chair. And another guy in a suit, who I, again, had never met before but recognized to be Bill Willis, was over here. And standing the window down at the other end of Bill's office was Al Knight. So I thought, oh man, this is, what in the world? I've done something wrong here. These people, I'm going to get chastised and run out of here. And so Bill said, come in and shut the door. And the fella in the overalls and Brogan boots was Jerry Thompson, who was a very fine reporter at the Tennessean. There was a cell of the Klan, Ku Klux Klan, down in Alabama that had been threatening violence and various other things. And John decided that one of his reporters was going to, join the Klan. And he picked Thompson because he thought Thompson looked more like a Klansman than anybody else he had on his staff. That's literally what he said. And so, once the infiltration occurred, Thompson was subject to being asked to do a lot of different things, some of which could be violations of civil law, and worse, they could be violations of criminal law. And so he had to have somebody that he could turn to get legal advice from. And so they decided that what they would do is to do what they called a telephone tree. And, Al and Bill were at the top of the tree, and I don't know who was in between, and I'm sure I was at the bottom, but in any event, the purpose of me being called in was to be told that that was all going to occur and that I should be available to participate if I needed to. So, John was famous for doing that. I mean, he sent folks to Central State and various other places, and he just was very aggressive as far as his work as a journalist, and extremely talented. The other thing, early on, the Tennessean was denied admission to a juvenile court proceeding out in Charlotte. Two little boys playing together. One had shot the other in the eye with a bow and arrow, put his eye out, and the case was being tried in juvenile court out in Charlotte, Dixon County, and the judge out there was not permitting the Tennessean to come in. So I went in and asked for permission to be admitted, denied, and so I had to immediately file a common law petition for certiorari and supersedes. I had to handwrite out on legal pad. John's told me to do this, and I presented it to Judge Birch, who was in the courthouse out there, and he granted it. He opened up the proceeding, and we got in, and I chased John down, and he was always amazed that I could find him. Ms. Gardner was his secretary during that period of time, and she was very prim and precise and all that. But I developed pretty quickly a pretty good relationship with Ms. Gardner, and then I was involved with John in trying to find an expert witness in a libel case involving Judge Dan Eisenstein, and so we had Dan and I and John had lunch together, I believe, on a Wednesday. here, and John couldn't have been more engaged and couldn't have looked more healthy and vigorous than he did. And then, of course, he had cancer. He went back into the hospital Friday after that Wednesday, and then passed away the next week. So I saw John within the last week of his life. Amazing.
Yeah. Well, we're going to come back to Willis and Knight a little later, but you left there in 1985.
March of 85, I believe. Yes.
And where did you go?
Well, Mike Passeno, my good friend from Knoxville originally, and who I'd worked very closely with, in the Attorney General's office, had gone to work for George Barrett. And Bill Willis's office and George Barrett's office at that time were at 215 and 217 2nd Avenue North. And there was a door that opened from Willis's side over to Barrett's side. There was really one building that had two different parts. And they had bought the buildings together. And of course, Dick Fulton had been was the mayor during that period of time. Bill and George, of course, politically and friendship-wise, very close to Dick Fulton. And one of Mayor Fulton's goals was to redevelop Lower Broad, 2nd, 3rd Avenue, and all the old buildings and preserve that architecture. So he encouraged Bill and George to be two of the early folks pioneers on 2nd Avenue. And they developed their offices and refurbished them really well. And so Mike was over with George, and I was departing Willis and Knight, and Mike and I decided that we would get together, and we then started practicing together. We had space up at St. Cloud Corner. Jack Waddy and Keith London and those folks had a sort of a recess area up there, which opened up into their wonderful law library. And Mike and I rented that space, and we practiced up there. And then we sort of outgrew that space, and we moved down to 3-something Church Street. I can't remember where we were. We were right. Harry Benaza had moved out of the Hermitage by that time, and had a liquor store right there on the lower end of Church Street, where you get to 2nd Avenue, and we were right across the street in that building across from him. And so we stayed there for a while, and then the Waddy Jennings firm broke up, and they still had a lot of time on their lease up at St. Cloud Corner. And so Hank Hildebrand, who was and is the Chapter 13 trustee in the Middle District of Tennessee, and who we had worked very closely with, Mike and I, had worked very closely with in the Attorney General's office, came down and asked us if we wanted to form a partnership and move back to St. Cloud Corner, and we did, and then we hired, associates. We had the first associate we hired was a woman named Jane North, who had clerked for Judge Merritt, who was bright, capable, wonderful person. And then there was a young fella who was in the Attorney General's office named Waverly Crenshaw, who had clerked for Chancellor Kilcrease, and who then also clerked for Judge Nixon. And Waverly came to work for us. And then a guy by the name of Mark Seitz was here. And Mark's father had been a chancellor in Delaware, who had decided a precursor to Brown versus Board of Education in the same way that the Supreme Court ultimately decided Brown versus Board of Education. And between the time that, or by the time that we hired Mark, he was Judge Seitz on the Third Circuit Court of Appeals, United States Court of Appeals. So we had a really good group of people. And then, I decided that after about 4 years, it was time for a change. And so in the late 80s, probably 88, 89, I sort of moved out on my own for a short period of time. And then I hooked up with a law school classmate named Mike Zinser. And Mike had worked for a firm called King and Lou, and they of course had represented newspapers all over the country. And of course, I'd had a fair amount of background working on editorial issues with the Tennessean, and so that was kind of a natural fit for me. And so Mike and I hooked up, and we hired associates, and I was there for a couple of years. Well, more than a couple of years, 3 or 4 years, and did a lot of local work here in Nashville, but also with a fair amount of regularity represented newspapers all across the United States. I'd get on an airplane, for example, on a Monday morning and fly to California and work for the Orange County Register, and then be out there a day or two, and then I'd come back either to St. Paul, Minnesota to represent the St. Paul Pioneer Press, or go down to Houston to represent the Chronicle, or down to San Antonio to represent what at that time was the San Antonio Light, which was a Hearst paper that ultimately merged with the Express News down there. Or I would go up to Wichita, Kansas, and work for the Wichita Eagle Beacon. And then at the end of the week, I would end up in Savannah, Georgia, representing Patrick Media, which was at the time the largest outdoor sign company in the United States. And also during that period of time, I represented Vince Moran in the Sheriff Fake Thomas criminal investigation, and did a lot of other stuff. So that was that group. And then next, I went to Grissim and Hodges, and although I wasn't a part of that firm, I worked a lot with those folks. We were all together. And I was there for about 19 years. And then, as I said earlier, in August of 2010, I came over to Tune Intric, and I've been there ever since. They fortunately have not run me off. So,
well, that's quite a track, Bob,
yeah.
From start to finish. So let's back up a little bit and talk about some of your cases.
Okay.
First one I have on my list is a case called State Board of Regents versus Steuben Gray. And I seem to remember something about that.
Yeah, if I remember, you were the chancellor who heard that case initially.
Yeah.
And, well, interesting case. I mean, the Administrative Procedures Act was the, sort of the nub of the whole lawsuit. The Administrative Procedures Act had not been enacted very long. I mean, it wasn't the law in Tennessee for long. As I recall, there was one reported case at the time that I brought that one. And I was in the clinical program at Vanderbilt. We picked that up. The plaintiffs in that case were 3 young Black women who were students at Tennessee State. And they were members of sororities over there. And the sororities, and I suppose the fraternities, I don't know for sure, but I think that they had a pretty good history of being pretty tough on people who were pledging, and they'd whack on them pretty good. And at some point, with paddles and those sorts of things, at some point, the administration over Tennessee State became upset and concerned about that. They were afraid that, somebody's really going to get hurt, and they wanted to nip all that in the bud. And so the initial thrust of their effort to do that was to throw these 3 young women out of school, expel them. And they went through a disciplinary process over there, which was pretty slim in terms of, the amount of process that was due. And so I don't know how it came about that they got over to the clinical program at Vanderbilt, but they did, and they talked to me about it. And again, I can't remember the specifics of all of this, but somehow or another, it came to me that maybe the process that they had received was less than they should have, particularly since it appeared that the contested case aspects of the Uniform Procedures Act applied to disciplinary proceedings within the state colleges and universities of Tennessee. And so that's essentially the case that we brought. And of course, Dick Lodge, who I subsequently practiced law with at Willis and Knight, was in the Attorney General's office. He'd just come out of Jim Sasser's office in Washington, D.C. And we tried that case in your court. I was fortunate enough to convince you that we were correct about that. And so from the trial court's opinion, the expulsion was set aside effectively. I'm not sure exactly what the word was. But then, and I'm sure I'd read this in the statute, but the legislature, in its wisdom, had decided that any appeal from with an Administrative Procedures Act opinion had to be directly to the Tennessee Supreme Court. So the first case I ever tried as a lawyer in your court ended up in the Tennessee Supreme Court in relatively short order. Of course, the judges or the justices who were on the court at the time were Justice Henry, Justice Harbison, Justice Bones, Justice Brock, and who am I leaving out? Justice Cooper. And they disagreed with us on that case. The issue was in the Supreme Court was whether you had to have actual knowledge of the issue or whether or actual notice was enough. The Tennessee Supreme Court decided actual notice was sufficient, and therefore they reversed the case. My memory is that somebody, the next session of the legislature, went to the legislature and wanted to clarify the statute to make sure that everybody knew it was actual knowledge as opposed to actual notice. And so that was my first case. And I mean, as I told you the other day, I was a total novice in all that. I mean, I can't remember. I don't think, it seems to me that we decided the case as a matter of law, that there wasn't much of any proof or everybody agreed about what the facts were. It was just what the law was. Dick was arguing pretty stoutly and effectively, as I recall, that it didn't apply and the statute didn't apply, and you decided otherwise. But here's the bottom line of that. By the time that the case went through the whole process, the girls who went back to school graduated, and effectively, by virtue of delaying everything, they got the education that they were entitled to. So that was, I always felt good about that.
Well, you were right about the Administrative Procedures Act being fairly new to the city. And as a trial judge, I found that the review of administrative decisions was a mess. See, trying to review them under the writ of certiorari. And it seemed to me like they had a rule in the handbook, but it hadn't been through the process to be an official administrative rule. So they got that straightened out. But let's talk about the case of John Albert Heffelfinger versus Vince Thompson, the warden.
Well, that was a 2254 petition, if I remember correctly, and a 54, 55, 54. And the reason that case was interesting to me is because there is a rest area shortly past Kingston, and above the Longville Road exit, and this young woman had pulled off and was asleep in her car in that rest area. And Mr. Heffelfinger gained entry to her car and raped her. And that case was tried, the rape case was tried in Roane County. And so I was in the Tennessee Attorney General's office, and Kenneth Dethridge, who I had been a grown-up when I was a small child, was the district attorney up there. And it just tickled me to death to get a chance to work with Kenneth in his office up there. And the 2254 was presented, 28 U.S.C. 2254 habeas corpus was presented in Judge Taylor's court up in Knoxville. And the challenge basically was prosecutorial misconduct. And one of the big issues in the case was whether or not the closing argument of the prosecution to the jury had exceeded, the proper constitutional bounds. And I wrote a response to all of that, and basically said in part that while I didn't vouch totally for the prosecution's argument that it was not constitutionally improper, that the argument was deterrent to demonstrate deterrence as opposed to anything else. And of course, Judge Taylor, as you would know, was just, everybody was just terrified of Judge Taylor. I mean, he was a fine man. Wasn't anything wrong with him at all, but man, in his court, he just ran roughshod over everybody. I mean, that's all you can say. And of course, I believe he was a Roosevelt appointee, not a Truman appointee. And so he had been on the bench for a long time. And of course, his courtroom was just dark as a cave. And he had a lamp on his bench, and he'd lean way back in his chair, and then periodically he'd come out. And of course, his finger was arthritic, but he would stab you and yell at you with that finger. And so everybody was just scared to death to go up there. But my response in that case became his opinion. I was string citing some cases. He took my string cites off and just cited one of my cases. But I was really proud of that because I was able to support my folks in Roane County, and Judge Taylor had adopted my response as essentially his opinion, and I thought that was, a pretty good thing. I thought, at least on that one, I'd done a good job. And so, and we kept Mr. Hammelfinger in the penitentiary where he deserved to be. And so that was that case.
And it was about whether the prosecution had made an improper argument.
Yes. Yeah.
And he found that
they had not.
They had not.
Yes.
Well, I guess Heffelfinger deserved what he got.
I think he probably did. That was like some pretty bad crime.
Okay, let's talk about case of Randy Anglin and Timothy Anglin.
Yes.
Versus the state of Tennessee.
Well, Randy and Timmy Anglin, part of what at that time, all kids who were sentenced to the Department of Correction that's probably, I'm going to say that was maybe a 75 or 76 case.
79.
Well, 79 is the opinion, yeah.
Was the appellate.
Yeah. But it was while that all came up while I was in the clinical program at Vanderbilt. And part of what we standardly did was that we sent ourselves and students out to the juvenile reception center, which at that time in Nashville was on Hyman Street, to interview kids who were coming in to try to determine whether or not they had been validly committed to the Department of Correction. And I think I was the one, I just, wrote luck. I was the one who talked to Randy and Timmy, and, they were down from Centerville. Their father, John Anglin, was a cab driver down there. And Centerville wasn't a big town, and there wasn't much call for a cab. So John supplemented his income by delivering liquor to various folks. So he wasn't the most upstanding guy, and he didn't exercise a lot of supervision over Randy and Timmy. And they had broken into the Baptist church down there and stolen some record players, as I recall, and maybe some other stuff, but record players have come to my mind now. And so then they were back in that era, we had county judges in Tennessee who handled probate matters, but who were also, of course, the chief administrative officers of the county, chief executive officers. And the Hickman County's county judge was a guy by the name of Hunt McClanahan, who was not a lawyer, but nonetheless had jurisdiction over probate and juvenile court matters. And so he correctly appointed this lawyer down in Centerville to represent Timmy and Randy. I guess you could probably say they needed two lawyers, but they got one. And so he then had a trial with respect to the theft charges that they had, burglary charges. And they tried it in the morning. Then they broke for lunch. And apparently Judge McClanahan had enough testimony in the morning that he was ready to decide. So he called their lawyer right before it's time to start back and said, "You don't need to come. These boys have decided to plead guilty and you don't need to be here." So, I mean, the lawyer took the judge at his word and he didn't come back. And of course, he sentenced him to the Department of Correction. And I interviewed him out there at the Hyman Street Reception Center. And they told me that they didn't want to plead guilty, that the judge had made them plead guilty, and that they wanted to go through the process. And so it seemed to me that there was a good faith basis for, habeas corpus petition. And so I filed it, and it ended up, Howard Cook was the superintendent. They were out at the local juvenile facility here in Nashville. And I can't remember, I guess Bob Bruno came in right at the beginning of that. He was in the Attorney General's office. He represented the Department of Correction. Subsequently became a commissioner of the Department of Human Services here. Wonderful guy, made not a piano, but some kind of musical instrument from scratch. He did it himself, and was a hot air balloon flyer and all this stuff, and just a great guy. So in any event, we did try that case in your court, and Judge McClanahan was here, and I cross-examined him pretty vigorously, as I recall, because it seemed to me that he'd done a pretty bad thing. It turned out that, in fact, I mean, a lot of times your clients tell you things that are not true, but in this particular case, everything those two little boys had said was exactly what had happened. And it seemed to me that was a pretty bad way to go at things. Force folks to plead guilty and then send them to some sort of confinement. And so initially, I raised the absence, the denial of counsel and voluntary and involuntary confessions and all of that sort of thing. And I was mindful of the non-lawyer judge issue at the time. There was a lawyer down in Tullahoma who had brought a case. And Justice Henry, as you would know, Chief Justice Henry was interested in this issue. But there was a case out of Knoxville that had come up that was procedurally defective, and the court couldn't reach the merits of the issue. In the Williams and Weiser case, which was the case from down in Manchester, there was something wrong procedurally with that, and they couldn't reach the merits. And so we tried the case in your court, and ultimately you decided that proof wasn't strong enough to support the denial of counsel and that the confessions were voluntary. But in giving your opinion about the matter, you, as I recall, you asked me if I was familiar with the non-lawyer judge issue, and I said I was. And and having not prevailed on those other two issues, I decided to file a motion to alter or amend and raise the non-lawyer judge issue. The reason I had been cautious, I guess, about raising that issue is because shortly before we tried this case, the United States Supreme Court had decided a case called North versus Russell. And that was a case out of Kentucky that Dean Rifkin brought and argued in the United States Supreme Court. And he was with, at the time that he brought that case, the legal services organization called Applered up in Kentucky. And that was a case involving a non-lawyer general sessions judge who had sent somebody to jail. And basically, the argument was from the petitioner's side in North against Russell was that, judge who was not trained in the law couldn't really apply the law properly, and therefore it ought to be unconstitutional to have non-lawyer judges hearing this kind of case. Kentucky had a system that's very similar to ours in Tennessee, which is that if you lose in the General Sessions Court up there during this time, you've got a de novo appeal to a circuit judge who is a lawyer. And that's what the Supreme Court held, that while the General Sessions judge, whether the General Sessions judge, was proficient in the law or not, didn't make any difference, because ultimately there could be an appeal and you could get a lawyer hear the case who might decide something different or the same thing. And so, again, here in Tennessee, not only our General Sessions process, but that was the case with respect to our juvenile system. You could ultimately get to the circuit court. And I was afraid that, given the sensitivity of the issue, that I'd make some bad law here in Tennessee, and I thought I had another basis to decide that. But by virtue of your opinion, you forced me to address the merits of that issue. And so, and then once I did, you were good enough to rule for me on that, and in my favor and my client's favor, that which sprung them from the juvenile facility. Bob Bruno then, on behalf of the state of Tennessee, appeals that decision to the Court of Appeals. The Western section was in town to hear that. And of course, now, as you would very well know, I mean, each side has 15 minutes, but Western section was really interested in this case. And so, I can't honestly tell you that I remember exactly how long it was, but it seems like we argued that thing for 2 hours, and back and forth and back and forth. And then the Western section came up with an opinion that just didn't seem like it made any sense at all, really. And of course, back in those days, you could ask the Supreme Court to take it, and they had to take it. It wasn't a matter of permission to appeal and all that stuff. And so it got to the Tennessee Supreme Court. I wrote that brief, I think, while I was still in Knoxville at the clinical program up there, and then came back and went to work for the Tennessee Attorney General. At the time that the Anglin case came up to be argued before the Tennessee Supreme Court, I couldn't argue it because I was a member of the other side. And Jerry Black, my friend and protege from Knoxville, came down and argued the case to the Tennessee Supreme Court. And although they decided the denial of counsel and the involuntary confession issue as well, the court, the big issue was for the court to take a look at the constitutionality of a non-lawyer judge committing juveniles to the Department of Correction. And on that issue, the court split 3-2 Chief Justice Henry, Justice Bones, and Justice Brock ruled that it was unconstitutional under the Tennessee Constitution for a non-lawyer judge to commit juveniles to the Department of Correction. And Justice Harbison and Justice Cooper dissented about that and said that really was not a decision that the judiciary can make. And it was a legislative decision that the legislature had to pass on, and they therefore didn't think that that the court could declare the case or the action by the non-lawyer judge unconstitutional. So that was a huge case in Tennessee, and the reason it was really important, for example, probably the most kids during that period of time who came into the Department of Correction were from Memphis, and the juvenile judge down there at that time was a guy by the name of Judge Turner, and I don't remember his first name, but Judge Turner was not a lawyer. And so as a consequence of the ultimate outcome of that case, they had to set up a special deal. I mean, non-lawyer judges could hear juvenile cases, but they just couldn't hear cases where kids potentially were going to lose their freedom and go to the Department of Correction. And after that case came down, there was a legislator who was in the Judiciary Committee in the House, and I can't remember his name now, but he sent me an invitation to come up and testify before his committee. And when I got it, I was really sort of honored. I thought, well, wow, I don't get these every day. And actually, as it turned out, all he wanted to do was to get me up there so he could yell at me face to face and tell me what a knucklehead I was for having asserted such a crazy position in the courts. And but that was a huge case in Tennessee.
It was, and the two dissenters were very fine justices.
Absolutely.
And part of their argument was you didn't have to rely on the non-lawyer judge. So you could have reversed on these other issues.
Right.
But the majority felt so strongly about it, they didn't go along with that.
Right.
So that was interesting.
Well,
change in the law in Tennessee.
Absolutely. And of course, I mean, by anybody's standards, Chief Justice Henry was a dynamic guy. I mean, he is, as you very well know, had been Adjutant General of the state of Tennessee, and was at Clinton at the time the school was bombed up there. And my dad was up there too, Clinton is in Anderson County, and Roane County is the adjacent county, and part of Oak Ridge is in Roane County. And so all the local law enforcement folks were out there. Governor Clement, of course, sent Chief Justice Henry, at the time Adjutant General Henry up there with the National Guard to maintain order. And so he'd done all that. He wanted to be on the Tennessee Supreme Court for a number of years. He and his brother, Joe Henry, very prominent lawyers down in Pulaski, and Sam Lewis, I think, was their law partner. And so they were, so he was just a very prominent guy. He didn't make it on the Supreme Court through Governor Clement. He was appointed later on, or he was elected later on. And I guess if I remember, that judicial election was in '74, where the Democrats put a slate together, and Joe Henry was one of them, and they were all, and really a very fine court and a turning point in terms of the judiciary in Tennessee at that level. And so Justice Henry was very activistic, particularly in the area of criminal due process and things like that. And so he really wanted to get to that issue, and he did, and it made a difference.
Stuck with it, yeah. And I do remember a picture of Justice Henry when he was Adjutant General. He was at the head of the guard driving into Clinton in his Jeep. He was leading the forces to maintain order. And this is an apocryphal story, but apparently he thought he was going to be appointed to the Supreme Court by Governor Clement, and Governor Clement appointed Chester Chatton instead. And Joe was heard to say, "Gee whiz, sitting in the rear by my own hound dog." Stronger language than that.
I'm sure.
Okay, that's very interesting. How you doing?
I'm okay. If you're ready, if you want to take a break, we can.
No, let's go ahead. Okay, we come back to Willis and Knight, and interested, especially in the case of Clyde Ed Hood.
Clyde Edward Hood, a handsome young man. We tried that case in 1981, and I was 31 years old, and Ed was about 3 or 4 years older or younger than I was. Married to a beautiful girl named Betsy, and they had 2 lovely girls. Ed and I formed a real friendship and bond in that case. Ed, at that time, was the youngest person who was ever appointed to a cabinet level position in Tennessee. And Ed was a brilliant young guy. He, and particularly as it related to finance and big financial transactions. And he was in college at UT Nashville. And again, in 1974, there was a Democratic primary, and there were a number of really good people running for the Democratic nomination that year. Gil Merritt, Judge who became Judge Gilbert Merritt, Tom Shriver was in that race, if I remember correctly. And wasn't Tom Wiseman in there? Tom Wiseman was definitely, no question about it. And so some really very qualified people. Ray Blanton was a congressman from West Tennessee, multi-term congressman. Nobody knew much about him, but he managed to win the Democratic nomination. And because there were so many candidates in the Democratic primary, there weren't many campaign workers to go around. And so Ed had an association with somebody who was in Governor Blanton's campaign. They got him into the campaign. He left school at that time. They found out pretty quickly that he was really a financial genius, and that he was very effective. He started raising money for the campaign, and very successful in that regard. Tommy and Billy Wilson, friends of his, and they were also close to Governor Blanton. So after Blanton won the general election, he gave Ed a job. Ed went to work for him. I mean, his position was, he was head of appointments up there, and continued to raise money. As a matter of fact, Jim Sasser subsequently was running his first race during the period of time Governor Blanton was governor. And Sasser, of course, ultimately won the nomination and was elected. But in the beginning had mortgaged his home to raise funds to run and all this stuff, and was about to lose his home and was at wit's end. And the governor called Ed out to the mansion, for an example, and said, look, you need to raise money for Sasser. And Ed did that and was very effective and was instrumental in his ultimate election to the United States Senate. And so he just, and his mother had worked in the United States Marshal's office for many years. And his father was an interesting guy. Clyde Hood. So Willis and Neal had at various times represented Governor Blanton in various investigations. The Blanton years, as we all know, were years of, scandal. And for example, an issue had risen about whether pardons were being sold for money, and Eddie Sisk, who had been the governor's general counsel, and who we all knew and liked, had been, deeply involved in that and been arrested for that. And there was, suspicion that Blanton knew about that and profited from it and had sanctioned it, or had said, okay, you can do it and all that. None of that was ever proven. But Blanton was cast in a bad light as a consequence of all of that. So in 1975, the Tennessee Supreme Court decided that liquor could be sold in other areas of the community or outside the urban services district. The rationale, of course, had been that liquor, was not a good thing to have around families and kids and so forth. And so the sale of it had to be confined to the urban service districts of major cities. And as I recall, the Supreme Court case in 75 came out of Chattanooga, but then applied to all of the major cities in Tennessee. And so that put the governor of Tennessee into a position to sell or to have appropriate qualified people come in and be selected for liquor store locations. And of course, those people who had been active and prominent in campaigns and who contributed to the governor's office saw that as an opportunity to get into a very profitable business venture. For example, in Nashville, the two locations with the highest traffic counts was a location in Donaldson, and then the other is where Bud's Liquor Store is out on Abbott Martin in Green Hills. Yeah. So those were two highly sought after locations for liquor stores. The Alcoholic Beverage Commission in Tennessee, ABC, was the outfit that decided whether you were qualified to meet all the requirements to have a liquor store. So a fellow contributor by the name of Jack Ham, who'd been in the construction business here in Nashville over the years and made a lot of money, particularly during the years when the interstate highways were being built. Jack Ham Construction Company was one of the individuals who was interested in obtaining a liquor license. And during the years that Ed had been in the governor's office, he and Jack and Jack's wife and Betsy at the time had become socially friendly, and Ed planned to go into various business ventures with Jack after he left the governor's office and after an appropriate period of time had elapsed. But they, ultimately fell out with each other, and Jack Ham and his brother Bert became the targets of criminal investigations by the federal government for various things. And so Bert had been in the military, some branch of the military for a number of years, had a military pension and all that. And so as the federal government started to squeeze him harder, he started deciding to cooperate with the government because he didn't want to lose his pension and other things. And he planned to give testimony against Jack Ham. And so Jack, won't get into all of this, but Jack made an effort to change his mind about that. Ultimately, for a period of time, both Jack and Bert were represented by Don Smith, who was very prominent in well thought of lawyer here in Nashville. So efforts were made to change Bert's mind about cooperating. Ultimately, that fell through. Jack then became the focus of the squeeze from the federal government. And he ultimately told the federal government that he had gotten the liquor store in Donaldson, which had the highest traffic count, because he had agreed to take ownership of what he called a defunct limited partnership interest in some oil petroleum development and it was a deal that Henry Hooker had put together, believe it or not. It's funny how all these people come into play. And of course, not only had Governor Blanton bought that investment, but Dick Fulton and other, prominent Ed Nelson, other prominent Nashville folks had it. But it had not been successful. Blanton was wanting to get rid of it, according to Jack, and he agreed to take it in exchange for this location. Well, virtually all the people who applied for liquor licenses after the Supreme Court decision were friends of the administration and contributors, and they were people who Ed had worked with. And so Ed was tasked by the governor. Clyde Edward Hood was tasked by the governor with, facilitating the process at the Alcoholic Beverage Commission. Lee Hyden was at that time the director of the ABC. Lee Hyden was a lawyer who'd maybe gone to a Knight Law School or something like that, but he'd been in the insurance adjuster in Memphis. He was originally from Shelby County and had come up and was involved in politics, and he came up here. And as the proof at the trial unfolded and in the investigation, the information that was submitted to the ABC during that period of time by most all of these people in order to get liquor licenses was not properly done. Bill Koch was working in the Tennessee Attorney General's office, represented the ABC during that period of time. And, and of course, Bill's a very bright, capable guy. And he quickly smelled something not being right in terms of just how the paperwork was being done. So it's pretty clear that these licenses were going to people who had been friends of the administration and who contributed money to them. And that in and of itself, there's nothing wrong with that. I mean, Andrew Jackson started that notion to the winner goes the spoils, and that was fine. But, you've got to go through the formalities in the right way so you can demonstrate that somebody who's getting a liquor license is appropriately getting it. And they actually could not do that. And so and there was a desire by that time on behalf of the FBI. Hank Hillen, of course, was the primary guy after Governor Blanton. And during that, I might say I got along very well with the FBI agents that I dealt with over the years, found them to be capable folks. But Agent Hillen, had a special desire to go after and get Governor Blanton. And so when Jack told his story, it was readily accepted. And of course, the precursor to him telling his story was that he was represented very capably by a very fine lawyer here in Nashville, who of course is no longer with us, George Barrett. And George, was negotiating primarily with Leda Arthur, who's now Leda Trogger, who's a United States District Judge here, and Bob Lynch. Hal Hardin was the United States Attorney. Hal had been appointed circuit judge by Governor Blanton, so he recused himself from any supervision over the case. Joe Brown was who was in the United States Attorney's Office, was the guy who supervised all of that. So in any event, George's first task was to negotiate for Jack Ham an immunity agreement with the government. In exchange for Jack's truthful testimony, government agreed not to charge him with any offense that they might charge any of the defendants in the Blanton, Hood, and Allen case. They agreed to not charge him with any criminal tax counts. They agreed to absolve him of any civil tax penalties, and they permitted him to continue to have the license to the Donaldson whiskey store, which at that time in the late 70s, early 80s was grossing about $1 million a year, and it's probably going to get better. So Jack got a heck of a deal. And Jack had some physical difficulties and had a large amount of his intestines removed. His doctor was a guy by the name of Magruder, and Dr. Magruder gave the United States government here his view that Jack was too frail to testify in open court at the criminal trial. So, and then Jack also, I think, included Ed Hood, Clyde Edward Hood, into his story about illegal means of obtaining whiskey licenses, because he just wanted to get rid of Ed as a business partner in a venture down in Jackson, Tennessee, so Section 8. Jack did not have a reputation for truthfulness and honesty, just to be honest about it. I mean, he was an old rat around the barn here in town, and anybody who knew anything about state and local politics knew that. His wife, Catherine, had been married to John Sirachi initially, who was the head of the vice squad here. And ultimately, after she divorced Jack, she remarried another Nashville lawyer whose name escapes me right now, but who I should know, and she remained with him until he passed away. But in any event, the government ultimately indicted Ed. There were essentially the charges in the case against Blanton, Hood, and Allen were mail fraud charges. Governor Blanton also had some Hobbs Act charges. Governor Blanton was represented by lawyers out of East Tennessee, and frankly, Governor Blanton didn't have any money. I mean, he left office early. If he was doing all this to, profit, he didn't do a very good job of it. And Ed, during the period where we were preparing for trial, went back to UT and got his college degree. And then in addition to that, he and Betsy got a contract to mow the right-of-ways on I-440. They'd grown up on tractors as kids down in Williamson County and bush hogging and so forth, and they made money doing that. And then Ed and I worked very closely preparing to trial the case. And Bill Willis, of course, was the primary lawyer who represented Ed Hood. I was the second chair lawyer, but Bill was always good enough in the big trials to, of course, I was sort of the case agent. I was the one who interviewed the witnesses and wrote the briefs and the motions, did all that stuff. But then in addition to that, Bill would let me participate in areas of trial that he thought were appropriate for me to do it. And sometimes they were really key parts of the trial. again, I was 31, and Bill at that time was in his late 40s, early 50s, and was a very experienced, capable trial lawyer, who any of the three of the defendants would have been lucky to have had represented. So, we embarked on Ed's representation initially when I went to Willis and Knight. I was involved in another federal criminal case involving our criminal court clerk here. We worked on that until a couple of weeks before Thanksgiving of 1979. And then we were involved in another case, which was an antitrust paving investigation. But at the same time we were working on that, it was actually related to the Blanton stuff. We were preparing for trial in the Blanton case, Blanton, Hood, and Allen, and then went to trial in that case, I believe in May of '81. And as I said, there were two sets of mail fraud charges. One related to the claims that Ham had made. The other related to claims involving Bob Towns. Jim Allen was a political finance guy for Blanton. He had a company here in town named McGregor Industries. Allen was originally from the Tri-Cities area, Johnson City. Nice guy. He was involved in business transactions that the governor's brother, Gene, had. And everybody always thought that the governor was sort of a undisclosed party in transactions. But again, I saw no real evidence that Governor Blanton profited from any of this. As I said, I and my family got to be very close to Ed and his family, probably in retrospect, too close, in the sense that, not that we would have done anything wrong, but it's more painful as the years went on to be that personally close to somebody who was feeling the kind of difficulty that his family had. It turned out that Governor Blanton's mother, who I met in the course of that trial, her maiden name was Delaney, and she was from Mississippi originally. And of course, they lived in Adamsville down in West Tennessee. But so after the governor introduced me to his mother outside the courtroom there on the 8th floor that Judge Morton used to have, he always called me Cuz after that. I wasn't sure whether that was a good thing or a bad thing. But in any case, Governor Blanton was, as far as I know, the first governor in Tennessee indicted, for criminal conduct. And so, I, by virtue of working with Willis, will always have a footnote that, I was involved in that case. And we tried it for, 4 to 6 weeks. The big issue in the case, of course, was I should say that the FBI case agent in that case was a guy by the name of John Gisler, who I liked a lot. And John and Vern Galvey, who was also an FBI agent, said to me one day, you don't believe Ed Hood is guilty, do you? And I said, no, I don't. And they just shook their heads because they knew I was just telling the truth. I wasn't kidding about that. The central issue in the case, really, as far as Blanton and Hood were concerned, was the truthfulness of Jack Ham. And if Jack Ham was telling the truth, they were guilty. If he was lying, then they were not. So, as I said earlier, Ham's doctor, Magruder, said he wasn't fit to testify at trial. Aleta Arthur, who graduated from Vanderbilt Law School in '76, and I graduated in '75. We were personal friends in law school, liked each other a lot. Still do, although we fussed some in this particular trial. The Latos had sat pretty straight to put Blanton in the penitentiary, and of course she succeeded in that. And Bob helped her a lot too. I don't want to leave Bob out of this. I mean, Bob's a very fine lawyer. So in any case, as a consequence of political circumstances, all the district judges here in Nashville recused themselves. And Judge John Peck, who'd been chief judge at the Sixth Circuit, came down to Nashville to be the trial judge of the case. And Judge Peck was a fine and gracious man in chambers, and was a bright and capable man, but had not been a trial judge for a number of years. And of course, we have had a tradition in the Middle District of Tennessee that the lawyers get to pick the jury, and judges won't just take that over and circumscribe the examination too much. Judge Peck didn't see it that way. He thought that there should be very limited examination of the veneer by the lawyers, and that he should ask the primary questions and so forth. And of course, there couldn't have been more pretrial publicity in any case that's ever been any place. That was probably an exaggeration, but there was a lot. It was all over in the local media and the national media. This is skipping ahead, but really one of the most terrifying events of my life occurred nightly during the jury selection. During the jury deliberation in that case. All the media were forced to stand out in front of the federal courthouse, old federal courthouse over here on 8th and Broadway. And the minute you'd come in, and the minute the lawyers would come out those front doors, or anybody came out those front doors, lights came on, you were totally blinded. And there are all these questions and so forth. And so that was just during the trial. Before that, the Tennessean, our other client, had just warned Governor Blanton out, in terms of the pretrial publicity, and the local media had as well. And so you had potentially a lot of jury bias, prospective jury bias, but not very much ability to probe that by virtue of the nature of the jury selection process that Judge Peck permitted. So we perfected those issues for appeal in the context of that whole process. I was familiar with the United States versus Dillinger case, which is the Chicago 7 case. And I thought that the jury selection permitted by Judge Hoffman in that case in Chicago was very much like the process that Judge Peck permitted here in Nashville. Again, I don't mean any disrespect to Judge Peck. He did what he thought was right, but I disagreed with him about that. That's how it was. And Bill Willis did a masterful job of perfecting those issues for appeal. Very sadly, toward the end of jury selection in the Blanton and Allen case, Judge Peck's wife died, and he had to withdraw from the trial of the case. And Judge Bailey Brown, who at that time was on the Sixth Circuit, but who'd been a very fine district judge in the Western District of Tennessee, came in to try the case. Judge Brown was a wonderful guy, personally and as a judge, and of course had gone to Harvard Law School and was very, very capable. And so we tried pretty hard, took a hard charge at Judge Brown to change up the jury selection process in that case. And judges don't like to second guess other judges in those kinds of circumstances. course, Judge Peck was, although he'd taken senior status, was a colleague of Judge Brown's at Cincinnati, and Judge Brown just wasn't going to do that. He just hit the ball where it lay in the rough and proceeded on with his way of doing things. I said earlier that Governor Blanton was represented by lawyers from East Tennessee, John McClellan. John McClellan was his reputation was as a labor lawyer up there, and he had been closely associated with Estes Kefauver in his days as United States Senator. And then John McClellan Jr. was Blanton's other lawyer, the son, and then a lawyer, a guy named Neil Rutledge, whose father was on the United States Supreme Court, was a law professor over at Duke Law School, and he was also Blanton's lawyer. And then Tyree Harris III and Tyree Harris IV represented, and a guy named Dick Pechtel from Johnson City represented Jim Allen, and then Willis and I represented Ed Hood. And so in two instances, it was pretty much a father-son relationship. And of course, I was Willis's acolyte. And so, it felt almost like a father-son relationship as far as we were concerned, although not formal. And so that was the lineup. The pretrial publicity and the jury selection issue were big factors. And as I said, it came down ultimately to who we believe, particularly as it related to Blanton and Hood. And because Magruder had opined that Jack was unfit to testify at trial, and because Judge Peck had agreed with that assessment, we took a videotape deposition in the days leading up to Christmas of 1980 in the federal courthouse, which was videotaped. And that was a really new process back then. I mean, these days, after we've come through the pandemic, Zoom and all that stuff, it seems like just nothing anymore, but it was a big deal back then. And as a matter of fact, we took that deposition right up until Christmas Eve, like 4 o'clock. And then my family and I drove to East Tennessee for Christmas, and then we left up there Christmas Day and came back and started the videotape deposition the day after Christmas. And in that, Jack Ham, if you were sitting there, appeared to me to lack a great deal of credibility. He had psoriasis. It looked like a snowstorm every time you were around him. He was a vulgar guy, just to be honest. He, when asked by one of the lawyers, I don't remember who, what he thought about his nephew Bert, he smiled and said, his quote was, "Pure ass dumb," and so that was Jack. And so Bill Willis, I thought, and Tyree Harris III particularly did very effective cross-examinations. But it didn't seem to me that at the time of trial that the videotape adequately conveyed to the jury the lack of credibility that I thought that Jack presented when you see him in the flesh. And so I think that was a factor. At some point before the case was over with, one of the jurors sent a note to Judge Brown and asked if they could have their picture made with each other. Well, when that happened, my heart just sank because it was pretty clear that where things were headed. And I said, my comment at the time was the only thing that's missing from the picture was the rope. And so we just hadn't been able to do the jury selection like Judge Morton permitted in the earlier Hawkins case, and that made a real difference and I'm convinced that the jury was tainted with, they probably didn't think so. I'm not suggesting that anybody misrepresented their view of the matter, but I just think the jury was really tainted by the pretrial publicity and the absence of live witnesses and that sort of thing. And so as a consequence, Blanton ultimately, the jury deliberated the longest with respect to the outcome of his case and ultimately convicted him of everything, including the Hobbs Act counts. Jim Allen had also had Hobbs Act counts against him, but Tyree Harris got those dismissed prior to the time the jury took the case for deliberation. Ed Hood only had mail fraud counts brought against him. The mail fraud counts and he was the only defendant who was found not guilty of something. And all the mail fraud counts that related to Bob Towns, he was found not guilty of. Mail fraud counts that he was convicted of related to, again, Jack Ham's testimony. And so, again, the pretrial publicity, the jury selection, the manner in which the proof was presented, all directly impacted on the outcome as it related to Ed Hood. And so I was not surprised, but obviously really saddened, I would have to say, by the outcome of the trial in that particular case. And again, to this day, I mean, of course, Keel Hunt, who's a great writer and great reporter, has written books about all this stuff. But not that I would be a worthy source of any information, but to the best of my knowledge, the perspective of none of the defense lawyers in this case has ever been, dug into by anybody. They haven't contacted me. Of course, they can't contact Bill Willis because he's no longer with us, and same with respect to Tyree III, and John McClellan Sr. is no longer there. And to the best of my knowledge, the second level of lawyers, Tyree IV, of course, is not practicing law anymore, but he's up teaching school someplace, and I'm here in Nashville, and to the best of my knowledge, nobody's ever contacted McClellan Jr., who's a circuit judge up in Sullivan County. And really, you'd have to say that in all honesty but respectfully, that Governor Blanton, in some respects, was his own worst enemy. He had some flaws and didn't handle all this in the best way that you could possibly handle it, and was sort of defiant, in different ways, but very likable, populistic. Aside from the scandals, did a good job, in my opinion, running Tennessee state government. I mean, his commissioner of finance and administration, Bill Jones, was a fine man. Nobody ever said anything bad about him. The vast majority of his cabinet were well-regarded people, and Murray Henderson, who was Commissioner of Correction, in the midst of all of the pardons and parole thing, never had anything said badly about him. And so I'll have to say, as I sit here talking to you now, there's still reasonable doubt in my mind to a moral certainty about whether Ray Blanton did anything for money associated with the issuance of these liquor licenses.
Well, I agree with you with that. I've always thought that Governor Blanton did not do anything bad wrong anyway, but the crowd that came in with him and all that liquor license stuff, they were in for the profit.
Oh, it was. I mean, and of course, the only thing that he would have had to have done in order to avoid all that is to make these people fill out the paperwork for them. I mean, that Bill Koch is the guy who was initially sounding the alarm about this, representing the ABC, and he was trying to get them to do the right thing up there, and they just wouldn't, Blanton, I referred to Earl Hawkins and Governor Blanton and Faith Thomas as dinosaurs. I mean, what had happened was that, warm weather had turned into winter in terms of the political scene in this country. And they thought that they didn't need to put their coats on because they just thought that they were subject to the old rules as opposed to the new rules. And Blanton was particularly guilty of that. There's no question about that. But again, I mean, there was never any proof that I saw that Eddie Sisk, for example, shared any money that he got with Ray Blanton.
And what he was convicted by or only amounted to what? A very modest sum of money, like $15,000 or something like that.
Yeah, it wasn't anything.
Yeah.
It just, it wasn't. And so in any event, I mean, of course, lost at the trial court, then appealed to the Sixth Circuit. That Bill and Al asked me to do the initial draft of the brief in the Sixth Circuit. Al and I talked about it, and as I said, Al was a brilliant guy, sort of an intimidating. I mean, he's so bright that he was intimidating, and he came to me one day and he said, this Dillinger case. He said, the challenge for cause part I get, but the peremptory challenge I don't get. Tell me about that. And so I said, well, if somebody says I'm biased and I can't be fair and I can't set it aside if you tell me to do it, and then that's pretty easy. But the question is, on the peremptory challenge, do you get enough information generally about a person to figure out whether they may have bias, even though you can't challenge them for cause. You just have to get enough information to figure out whether you should exercise peremptory or not. And given the truncated procedure that Judge Peck permitted, we didn't even get that much information. And he said, well, I got it that now. And so I did the initial draft, and then Al took it and polished it far better than I could have ever done, and went up to Cincinnati and argued the case to the 3-judge panel. And I don't remember who was on the panel. The thing that sticks out in my mind about the first argument was that Judge Gibson, who was the 8th Circuit, was sitting specially on the panel. And the first panel reversed the case on the jury selection issue. And then John Williams, who's my law partner, was at that time in the United States Attorney's Office. And Joe Brown asked, who was sort of the acting U.S. attorney in this particular instance, asked John to write the brief to ask for an en banc hearing. The en banc panel then reversed the 3-judge panel, and we petitioned for certiorari on all the same issues we raised in the United States Court of Appeals for the 6th Circuit. And ultimately, the Supreme Court denied certiorari in that case. And that probably was the biggest disappointment of my career, because I really was convinced to this day that Ed Hood was innocent of any criminal conduct. And you don't like that, goes against that grain. You don't like to think that innocent people are being convicted of crimes in this country, particularly very fine people who had the potential to do very big things and meaningful things in their life. So that was disappointing. Ed went to Montgomery Air Force Base and did 5 or 6 months down there, and then came back and was in a halfway house here in Nashville. He completed all that successfully. Governor Blanton went to Montgomery initially, and they gave him a pass for a little time off. He went out, unfortunately, drank some alcohol during that period of time, and when he came back, they of course tested him, and he was sent to a more restrictive medical facility, I think in Kentucky, but that was that. And then Jim Allen did his time and was out. I mean, they weren't long sentences, but again, I never felt really good about it. And of course, I continued to be friends. I mean, the night before Ed and Betsy, I mean, Ed went to Montgomery. I and my boys and Becky and Ed and Betsy and his girls had dinner together out at a pizza place out close to where they lived. And again, it's not, I mean, for the record, it's not a good thing to get that close to clients.
Yeah.
But we did. And so time passed, and Ed was starting to make money and do things again. And he and Betsy bought Jack and Catherine out of some Section 8 apartments down in Jackson, Tennessee, called Royal Arms. And so they had bought a farm up in Adairsville, Kentucky, called Dual Site Farm. And the dual side is where Jackson and Dickinson fought their duel. And the reason they fought it up there, it was on the Red River. Both legislatures in Kentucky and Tennessee had outlawed dueling, but there was a piece of property up there that was claimed both by Tennessee and Kentucky. And so they thought that since no clear ownership of the property and no state's law clearly applied, they could duel it up there. And of course, Dickinson had shot twigs off of branches on trees going up to entertain the folks who were riding up with him. And Jackson knew that in order to prevail, he'd have to let Dickinson shoot first. And so they rode up there, and of course, the rest of the story. I mean, Jackson had been in military campaigns and had dysentery, and his clothes didn't fit properly because he'd lost so much weight. And Dickinson shoots first and misjudges where his heart is, but shoots right above the heart, knocks Jackson down. Jackson gets up and fires, and his first pistol won't shoot. And under the rules, he's entitled to get the second one, and he does, and kills Dickinson. And Quincy Adams calls him a murderer in the election for the 6th president of the United States. Well, that's where this house was and farm. Yeah. And the house, beautiful home on the farm, was built with bricks that came out of the old Maxwell House Hotel on 4th Avenue there when it burned down. Hmm. And so as we drove back to that house, I went up there with them to close. The closing had been set to occur, and then they were going to renege on the deal. And because there was complete diversity, I filed an action in the United States District Court for the Middle District of Kentucky about the closing. And we had resolved that, and I was up there with them to close the house. High banks on the left-hand side of the road, the driver's side of the car. And Ed was meticulous in everything he did, and there were high banks and they were crumbling. And I knew how he was with a bush hog and a tractor, and Betsy would work out in the field with him. So the day we closed on the house, I said to him, I said, now, Ed, do not get out here on that tractor and get on these high banks with Betsy out here, because that tractor could turn over and kill her or hurt her. And of course, he didn't pay attention to me. And we closed on the house. We went back, and about around Thanksgiving that year, sure enough, he was up there bush hogging those fence rows the tractor turned over. He didn't have a roll bar or cage on the tractor, and he got caught underneath the wheel of the tractor. And it didn't crush him, but the weight of it was such that he couldn't breathe. Betsy ran to the road. They got the tractor off of him, but of course it was too late. They got him down to Vanderbilt, and he lingered for a while. I went to visit at the hospital after Thanksgiving dinner that day, and then subsequently Hank Hildebrand had heard, and my law partner had told me that Ed had died, and so he was not. I mean, he was a really young guy, and he had a very tough life, very talented.
Let's talk about the Brown-Forman Corp versus ABC.
Well, that's an interesting case. I mean, Brown-Forman and other major liquor distributors in the country and abroad had a strategy to knock out all of state regulated price fixing for the liquor industry. And they came to Tennessee to do that, filed a lawsuit. That indicates that the opinion is written by Judge Wiseman, but I was surprised about that because we tried the case before Judge Nixon. But in any event, the way our firm got into it, it was Passeno, Delaney, and Hildebrand. And Hank Hildebrand not only was the Chapter 13 trustee for the state of Tennessee, for the Middle District of Tennessee, but a position that Keith London had before him and that Judge Wiseman had before Keith, or Judge Wiseman's office. But Hank was also the lawyer that represents the licensed beverage sailors in Tennessee. And Keith had that before, and Judge Wiseman had that before him. And so when Brown-Forman decided to ask the court to declare unconstitutional the Tennessee affirmation laws, which were price fixing laws in Tennessee with respect to alcohol, obviously the licensed beverage wholesalers had a interest in that outcome. And so although the state of Tennessee was defending the constitutionality of the statute in the court, we were permitted to participate, I guess, as amicus parties in essence. And much to my surprise, instead of the Attorney General's office having the laboring oar in all of that, it ended up being us and me. Mike and I were doing it together. Hank asked me to do it, or Mike to do it, and so we essentially tried the case, and the proof was fascinating. One of the witnesses in the case, and I'll always remember this, was the general counsel for Brown-Forman, really nice guy. And there was some trade publication that in which whichever Brown was head of Brown-Forman at the time had given an interview. And there were a lot of statements that he had made that were relevant and inconsistent with their position in the litigation. So Judge Nixon permitted me to cross-examine him with that article. And he was in a very difficult situation because he wanted to give an answer which was different than that which his boss had given in the context of this article. And so he just danced all over the place. And finally, and it didn't end up as a very credible witness, and his testimony was not supposed to be very helpful to their side of the case, but as it turned out, it really wasn't. And so after we took a recess and we were out in the hallway, and he came out and he got this big smile on his face when he saw me come out of the courtroom, and he pulled out his shirt cuff and said, "Got my answers written right here, and I'm sticking to them." So that was funny. Judge Nixon ruled against us, and then I left the law firm and formed Zinsser and Delaney and then Mike was primarily, if not totally, responsible for the appeal. I mean, we made the record in the trial court, but Mike appealed it to the Sixth Circuit, and the Sixth Circuit reversed, much to the surprise of a number of folks. And then Brown Foreman asked for or filed a petition for certiorari. The Supreme Court granted it. But before the case could be argued in the Supreme Court, Supreme Court decided a companion case, which reversed the Sixth Circuit in our case as well. So that's the Brown. It was great working with the licensed beverage wholesalers.
Well, let's talk some about Delaney versus Thompson. Sounds like an interesting case.
Well, that Delaney versus Thompson, let me tell you how I got involved in all that. I mean, many people have wondered. And John J. Hooker, who we've talked about before, had a case called Hooker versus Huntington National Bank. And he had lost that case, not only at the trial court. Chancellor Brandt ruled against him at the trial court, and then the Court of Appeals sustained Chancellor Brandt. And what had happened essentially in Hooker versus Huntington National Bank is that John Jay had guaranteed a loan for a plant. But he said he did his due diligence, and beforehand, he basically said, I asked everybody whether there was anything different about this loan, or is there anything you know about this loan that I hadn't asked you about that I should know about before, I agreed to guarantee it. And they said no. And in fact, the proof showed that they knew that the principal on the loan, wasn't going to be able to pay it back. And it essentially, according to John Jay's allegation, trapped it. Jimmy Sanders represented all this. And so he lost that case. I had a similar case called JMD Bransford versus First American Bank. Chancellor Brandt ruled against me in that case, and I appealed it to the Court of Appeals. And Judge Todd and Judge Koch and Judge Sam Lewis were on the panel. I convinced them, Chancellor Brandt had ruled against me on summary judgment, and I convinced them that there were disputed issues of material fact that summary in the case could be decided as a matter of law. Had a very skeptical, but went along with it, Judge Koch. So John J. Hooker's good friend, Mac Davis, who he played tennis with at Bellmead Country Club as a boy, saw the case and said to John J., got all this stuff going on with election of judges and so forth. And look, here's a lawyer that has gotten exactly the opposite outcome in the same factual circumstance that you had. And you ought to go talk to him. Well, when I was at Willis and Knight, I mean, it had been Hooker, and Willis, and I had met John Jay once. He, of course, did not remember who I was. I remembered who he was. And I had his desk that he had while I was at Willis and Knight. So he came over to my office. I was at Grissim and Hodges during this period of time, and asked me, what my thoughts were with respect to the retention election process in Tennessee plan. And, I looked at it and really in some respects, it's the same issue that came up in the Anglin case. I mean, what power, if any, does the judiciary have to decide the manner of selection of judges in Tennessee? And ultimately in Delaney versus Thompson, I was really on the other side of that particular issue. I just said, I ultimately didn't think, and a number of other lawyers whose opinion I respected didn't think that the Supreme Court could make that decision, particularly as it related to the selection of judges at the appellate level in Tennessee. But most everybody thought that selection was a better way to go than election. But again, the question is what is the proper role of the judiciary and the legislative branch in all this? A further issue in Delaney versus Thompson for me was the fact that there had been an effort to amend the state constitution to have the selection process in Article 6 amended to provide for selection as opposed to election. And for the first time, and the only time, as far as I know, in the history of Tennessee, the constitutional amendment had been voted down. And of course, that the Tennessee plan came out of, the Constitutional Convention of 74, I think. J.D. Lee was the chairman, and again, or 74, 75, I can't remember. Bill Leach was involved in all that. But in any case, again, the activist Chief Justice Henry wanted to do a lot of things in addition to changing the process by which appellate court judges were selected in the state of Tennessee. And a couple of the things that he wanted to do were to create judicial districts. And in addition to that, he wanted to abolish the division between equity and law and just create one court that had concurrent jurisdiction for everything. And the problem with that is that meant out in the rural areas that you not only you'd have essentially a circuit court clerk, but you wouldn't have a chancellor. As we all know, many of the circuit court clerks and chancellors think that some of their relatives, friends, and so forth are qualified to work in their office and do things. So the general consensus that I picked up was that the reason the constitutional amendment, as it related to the Tennessee plan, was concerned, failed, was because there was a lot of opposition not to the change from selection to election, but because it eliminated, jobs for a lot of people out there. And so the activist Chief Justice Henry, who was well-intentioned, had not served his own purpose very well by adding on some things. And so, I really wrestled with whether it was a good idea to get into all of that or not. And among other people that I called Hal Levinson, who taught me state constitutional law. And I said, really, is this a prudent thing to do? Is this a worthwhile thing to do? It's not something I'm going to make any money doing. I mean, it has to be because I think it serves an important purpose. Or, as a matter of fact, I'll probably lose some money because I'm doing this. And he said, well, are you afraid that it's going to hurt your career? And I said, well, no, not really. I said, people might think I'm nuts, but they're not going to hold it against me. I'm not going to do anything that would cause that. And so he said, well, it seems like to me it might be something worthy to do. So I decided to wade into it, correctly or incorrectly. And of course, we filed the case challenging the constitutionality of it here in Davidson County. And I went through the process of obtaining a qualifying petition and turned that in and made myself a candidate. Whether it's a good idea to litigate in a case in your own name or not is another, matter that reasonable minds could differ about. But in any event, I weighed into it and we tried it in Chancery Court before Chancellor Lyle, Part 3. And she ruled for us. Well, pretty quickly, Mike Moore was on the other side for the Attorney General. He got into it pretty quick. They went out and got some sort of stay from Judge Russell. I mean, the other issue in the case was whether the sitting appellate court judges, both on the Court of Appeals and Supreme Court, could hear the case. And as you know, there's a special provision for recusal of the appellate court judges. And up until that time, when that litigation started, it had only been acted on once before in the context of when the retirement system changed. And interestingly enough, and coincidentally, Bill Willis was the Chief Justice in that special court who wrote the opinion saying that everything was done appropriately as far as the retirement system is concerned. And so the Court of Appeals, I guess, had recused themselves. Judge Russell, who'd been on the Court of Criminal Appeals, Judge Joe Duncan, and Judge Sam Lewis were the three special Court of Appeals members who heard Delaney versus Thompson at the intermediate appellate court level. They didn't think much of it, and it didn't take long for them to reverse the chancellor on that. And so then we were on to the Supreme Court, and again, you know, it would be fair to say that the Supreme Court of Tennessee was reluctant to recuse themselves in that, and understandably, I don't say that badly. But ultimately, they decided they needed to. I think, if I remember correctly, Riley Henderson was the Chief Justice of the Supreme Court at that point. And so the governor appointed a special court. I guess Governor Haslam was the governor at that point. And he appointed 5 members. And Ames Davis was, of course, here in Nashville at Waller Lansing. And he became the Chief Justice of the Special Court. And Judge Arnold was from up in East Tennessee. And the United States District Judge in Jackson's wife was also one of the appointees. And then Gary Gerbitz out of Chattanooga was on the court, and I'm blocking, I'm afraid, on the black civil rights lawyer from Memphis who was also on it. But you know, there was, I mean, in a lot of minority lawyers in Tennessee had been strongly in favor of selection versus election, because they thought, correctly or incorrectly, there was better opportunity to have more racial mix and balance on the courts through selection than election. I'm not sure that's proved to be true, unfortunately. So in any event, we argued the case. And I have to say this about Brooke Thompson. Brooke was the election coordinator for the Tennessee Secretary of State, and he's one of the finest guys I know. I ran into Brooke one day in the arcade, and I said, "Brooke, I think I like you better than any party I've ever sued before." He said, "Let's just keep it on the official basis as opposed to individual." I said, "Okay, we can agree about that." So Brooke was just great to work through with in this process, and 1 or 2 other election cases that I've had with him. I have the highest regard for him. He's become, I think, an administrative law judge, and as far as I know, after the administration changed from Democrat to Republican, he went on to other things. But in any event, he's really a fine guy. And so, you know, we argued it before, I argued it before the Supreme Court. Got some pretty tough questions. Ultimately, Justice Gerbitz said, "Well, what do you really want out of this? And you know, do you think that the Constitution needs to be amended?" And I said, "Yes, sir, I do. I mean, you know, there's some authority, legal authority, support the notion that a legislature," and of course, I think Cooper and Harbison would agree with this, that the legislature could pass the plan. And if they did, that was a way to go. But there's other authority, of course, that the Constitution of a state or anything else can only be amended by vote of people, because it's the contract between people and the government. And it seemed to me that that was an important principle to kind of establish. And of course, the court split 3-2 and decided the case on a non-merits issue, but sent it back to the trial court for further proceedings. And what had happened by that time, excuse me, is that Judge Todd had not run for re-election. There was a vacancy, and the governor had appointed Patsy Cottrell to be the judge. And so that meant that if I went forward with the litigation after it was remanded to the trial court, I would be, in a contested election against Patsy. Well, Patsy is, number one, is a very, very fine person. And she and I have become close personal friends when we were in the Attorney General's office together a zillion years ago. And she and Ross, of course, were just, great friends. Well, there's no way in the world that I was going to run in a contested election against Patsy Cottrell. I mean, even if I thought I could beat her, I don't know that I could have, and wouldn't have wanted to try. I didn't. And so we just non-suited that litigation ultimately and ended up with the Delaney versus Thompson thing. Of course, John Jay, of course, had sort of worn that issue out and worn his welcome out with the courts. Really a very complex guy, very brilliant guy. There's no doubt about it. He and Henry were brilliant. Henry was at the top of his law school class and editor-in-chief of the Law Review, and John Jay finished last, and the only reason he did is because he didn't want to try. It didn't have anything to do with ability. I had lunch with one of his daughters last Saturday, as a matter of fact. Continue to be very close with his family. But, he was a complicated, complex guy who you could disagree with in terms of his approach on some things. And but what you have to say about him is that he just never gave up. And he finally convinced really a virtually Republican-controlled state legislature to put forward an amendment to Article 6. And now we have it. And now I think it's been done the right way, in the way that it should have been done in the first place. And so, I kind of feel like ultimately I achieved the goal that I set out to achieve, hopefully without, offending any people in the process of doing it. I'm sure they didn't like it, but hopefully I didn't offend anybody.
Okay, let's talk about Lewis versus News Channel 5 Network.
Okay, there actually, we can talk about maybe two cases together, Lewis and Eisenstein together. Yeah. I mean, Bill Willis and I, in the Earl Hawkins criminal prosecution, we had a lot of pretrial motions. The RICO statute was new. There was a credible issue about whether RICO was designed to apply to, say, a political entity or individuals who were not engaged in organized criminal conduct. The legislative history of the legislation supported that argument. So we raised that issue and many others as an example. And we'd send them up to Judge Peck to look at Cincinnati, and he would rule against us every time. And Willis would say to me, he said, "Robert, I don't believe that one. It actually got to the edge of the Ohio River where Judge Peck shot him down." And so we joked about making law in reverse. I mean, we raised the issues and they decided for the other side of the case. And so, so in some respects, that's how I feel about Lewis and Eisenstein. Two very different cases. The Lewis case involved kind of a controversial figure in family here in this area, the Jimmy Lewis family, and Brad Lewis in particular here. He's got a country store out on Highway 12. And Brad had been who was the brother-in-law of a former Nashville fairly high-ranking police officer named Carl Dollarhide. And Brad had been stopped in a sort of roadblock situation where various inmates had escaped from the state penitentiary, and they were trying to get them, and when they found some stuff in Brad's car, or they thought Brad had somebody in the car who was maybe one of them, and they were going to arrest him and all of that, and so Dollarhide had been called to the scene, and he had basically persuaded the officer that nothing was wrong and they ought to let him go, and they did. And so then that became the subject of a big News Channel 5 story involving Phil Williams. And, my expert witness, who was a Pulitzer Prize winner in the Eisenstein case, basically talked about gotcha journalism, and Phil Williams to this day, and other people who I really respect would be very critical of me for having brought these cases. I mean, all my work over the years had been on behalf of a media company, starting with the Tennessean, and I'm a big proponent of the First Amendment, and I'm a big proponent of journalists. But I've come to believe that the old adage that to those who much is given, much is expected. And I think there are a lot of people today who would say that journalists don't maintain that standard. They've become too self-righteous almost, and kind of lazy in their journalism. And I really thought that Phil Williams was guilty of that, and on many occasions. Basically turn something, make a mountain out of a molehill, or turn something that's nothing into something apparently that reflects badly on public officials. I mean, it's one thing to, catch the juvenile court clerk in his house robe at 4 o'clock in the afternoon at home when he's, supposed to be at work at the clerk's office. It's another thing to, catch some NES employees asleep on the job. But when you start calling into question people whose reputations don't really deserve that, and particularly in the case of Dan Eisenstein, who had been and still is a real asset, in my opinion, to our community, and who's done a lot of good things, not the least of which is the mental health court and all that stuff that he's worked on. You need to be more thoughtful about it and act more responsibly. And so in the Lewis case, basically the issue was whether Brad was a public figure or not. And then there was an issue about whether the publication of certain thing was privileged because it was a matter of public record and all that. And Judge Kurtz had ruled that Brad Lewis was a private figure, but that the publication of essentially a transcript that was a public record, was privileged, and therefore there was no real cause of action as far as the case was concerned. We appealed that to the Court of Appeals, and Judge Coke got a hold of the Lewis case, and basically he ruled that we were correct with respect to the privilege issue, but that Lewis was a public interest, public figure, because the matter as to Brad's release was a case of a matter of public concern. That's a ruling of first impression in Tennessee. That certainly is the law if the facts warrant it. But Judge Coke, made some new law, and therefore, back to my story about making law in reverse for the other side. Judge Coke did that for me in that case. With respect to the Eisenstein case, that was the more troubling case for me, because I felt like, based on the information that I had, that Mr. Williams' motives were suspect. Mr. Williams tried to enlist Judge Eisenstein's help on various things, and Judge Eisenstein didn't think it was appropriate to do that in his role. And moreover, Mr. Williams was trying to make the case that a number of our General Sessions judges here in Davidson County were corrupt, and he had used his influence and reputation to move the needle far in that direction with some local prosecutorial officials, and not only state but federal, and based on incorrect assumptions. And Dan Eisenstein, as the presiding judge of the General Sessions Court here in Davidson County, had done a yeoman's job of undercutting the work that Mr. Williams had done in that regard. I took it that Williams had, in fact, decided to target Dan rather for inappropriate reasons, as opposed to anything that would fit within the four corners of what a journalist was supposed to be doing. And I thought that there was a valid lawsuit there. That fact was further compounded for a long. We'd had requests for production of documents and interrogatories out, and didn't receive until we took Mr. Williams' deposition in this building at Neal and Harwell, a letter which Williams had written to the Tennessee Court of Judiciary that was very critical of Dan Eisenstein without any basis, it seemed to me. And so the question of actual malice, really, I thought was a palpable and live issue in that case. And of course, the law is very tough on that, as you know. I mean, New York Times versus Sullivan is a pretty high bar to jump. And but I thought that there was genuine issues of material fact with respect to all of that, and that it was a case for a jury to decide, and that it could not be decided as a matter of law. Initially, the case was dismissed by a special chancellor from Memphis, who had been a chancellor in Memphis for a number of years. We appealed it to the Court of Appeals. The Court of Appeals sent it back to the trial court had sustained the dismissal on some issues, sent it back to the trial court on a couple of issues. According to former Court of Appeals Judge Dinkins with the intent for it to be tried. And then we went through a couple of different senior judges. We ended up with Judge John Kerry Blackwood, and Judge Blackwood decided that it shouldn't be tried, that it should be decided as a matter of law with respect on those two issues. Granted summary judgment against us. It was appealed to, we appealed it again to the Court of Appeals, and the Court of Appeals sustained that decision. So again, I thought a disappointing outcome. I mean, everybody very well intended. I'm a big supporter of the press. Mr. Williams would not agree with me about that, but I am. I just think that they ought to not, and I think that, again, I will just have to say to those who much is given, much is expected. And I think we expect more from the press than to beat up people who are doing their darndest in public as public officials to do the right thing and to administer the system of justice here in Davidson County or any place else the way it's supposed to be administered. And so that's the reason I got into that. I mean, I burned some bridges with friends about that, I think. Although one of the friends that really was very supportive about all that was John Sigenthaler. I mean, the subject of our last lunch together and with Dan Eisenstein present was, expert witnesses and also, the propriety of going forward with this. And John was very supportive of it, by the way. If he had told me that he thought I was way off base, I probably would have listened to him and advised Dan accordingly, but that's not what he said. So those are those two cases. We've, again, I've established new legal principles in support of my opponents in both of those cases. But
okay, I'll just talk about a bankruptcy case. It's called Henry Thomas D. Binkley and Penny Willis Binkley.
Well, that Kim Binkley is now the sheriff of Cheatham County. And I, being the son of a sheriff, am very familiar with elections for sheriff, and they're usually very hotly contested events. And Tim was elected sheriff of Cheatham County without any opposition. And so the parties in that, and so it involves the sale of a home that Tim and Penny owned down in Cheatham County. They sold it to this fellow who had been in the military, he and his wife. There was flood damage and this and that. And they all brought all kinds of claims. And the case was pending down in Cheatham County for a long time and didn't get resolved. Nobody was in a big hurry to decide, a case involving Tim down there. And so the plaintiffs were ably represented. They essentially removed the case to the United States District Court for the Middle District of Tennessee. And it was assigned to Judge Joe Haynes. And we were scheduled for a jury trial in that case. And I didn't think that was the best way to approach the resolution of that case. And so I advised Tim and Penny to file I can't remember whether they filed an 11 or 7 bankruptcy case, because it seemed to me that it ought to be a case that could be dealt with over in the bankruptcy court as opposed to the district court. It's going to be really expensive and hard to try that case to a jury. And that's what they did. And I've included that case in this to just show the variety of my practice over the years. I am not a bankruptcy lawyer, matter of fact, when they see me in the bankruptcy court, they make fun of me because I'm never over there. Paul Jennings said one time, he said, who was bankruptcy judge here, of course, many years and who I think the world of, Paul said, you know, boy, somebody must really be in trouble if you're over here. so they make fun of me, but they don't try many cases over there. And in this particular case, the plaintiffs had missed their window to file a non-dischargeability claim or action. And so we tried the case as a claim issue before Judge Randall Mashburn, who's a great judge and a wonderful guy who I think the world of. I've known Randall ever since he came up here and went to work for Jack Waddy and Paul Jennings and it's gone on to greater things. But basically, there was a $900,000 claim against the Binkleys in that case. And we tried it for 3 days in Judge Mashburn's court. And ultimately, he awarded $9,000. So that was a, major victory for the Binkleys. And again, it's another, not only is it a demonstration of the variety of my practice, but also the Willis rule that, as long as you've got a lawyer to keep you straight on the law, a litigator ought to be able to try most anything. So and I had Joe Rusnick, my partner now, current partner, and then helped me with the law, and we tried the case and we were successful. So
yeah, I was going to ask you, relying on Bill Willis's advice about a good lawyer could try any case as long as he had somebody instructing him on the law.
Right. It helps to know. You learn a lot of different law. It's again, the practice has changed. The bankruptcy judges like to have people over there who, for the most part, who try exclusively bankruptcy cases. When Judge Robinson was on the bench trying domestic cases, Judge Muriel Robinson, she liked to have people in there who exclusively did, divorce cases. And, and the criminal judges love to have people who exclusively try criminal cases. And that absolutely is totally inconsistent with the Willis rule about trial practice. You ought to try a lot of cases and have a lot of different perspective on things. And I guess I have adopted that philosophy.
Well, let's do this one. It's a fairly recent case, 2020, Story versus Meadows. Pretty big deal around this.
Story versus Meadows. Yes, sir. It's a big deal all over because, of course, Story versus Meadows is the case of a huge family dispute. A fellow by the name of Don Meadows, who was a poor from a family that didn't have much money and lived down in Cheatham County. And Don had to leave school pretty early on after the fourth or fifth grade and work in order to support his family. And was pretty rough and ready, and started initially a landscaping company, which turned into a sort of a grading and utility installation company in addition to the landscaping, and became ultimately Meadows Excavating, and Don by 1987 had amassed had accumulated probably $4 or $5 million, just working hard and working his family hard. And in 87, his son wanted to start a concrete company, Nashville Ready Mix. And Don and his wife pledged all their assets, and the assets and the use of assets in Meadows Excavating to help, get that company going and make it very, very successful. Didn't have any formal partnership agreements, none of that. But there's no question that his financial circumstances were the thing that enabled his son to successfully run with this concrete company. And Don worked in that company. Really, he was the manager of all operations. Son Steve had a high school degree from Father Ryan and was more sophisticated than his father. But in terms of actually running the business and getting the dump trucks to the concrete plants with sand and gravel and making mechanics always work and hiring and firing and overseeing the completion of jobs. I mean, the father was the guy who did all that. The son, it's pretty clear from the proof in my mind, handled a lot of the business details. And so in 2012, I guess it was, 2013, the father and son had a big falling out as a result of the wrongful death of a construction worker down at Cheatham Dam. And son, according to our side of the case, ran the father off from Nashville Ready Mix and Meadows Excavating. And then in 2016, father passed away. And so this 4 lawsuits were filed. Gino Marchetti, who's a fine Nashville lawyer, initially represented the Don Meadows side of the case, but by virtue of his representation of the Meadows in general and the companies, Chancellor McCoy decided that he had to be a witness and couldn't had a conflict as it related to everybody else. And so he withdrew, and then in April of 2016, we got into the case. The 4 cases are, one, whether there is an implied partnership between Don and Steve as it relates to the Nashville Ready Mix companies. And the case that you just asked about is the appellate decision in that particular case. And then there's one involving the dissolution of Meadows Excavating, in which the Court of Appeals has ruled, after the case that you have referred to, that the dissolution process approved by our chancellor in that case was appropriate, and so we're out on that case. And then there are 2 partition cases involving jointly held property by Steve and Don. And we've sold off the property in those cases and made several $1 million there. And Clark & Master still has about $1,700,000 from those sales to be distributed to the parties. And there's probably going to have to be some litigation about that if we can't settle it up. And so one of those pieces of properties was 1326 Baptist World Center, which is over across the Jefferson Street Bridge onto Callan Street, back a little ways. And it's a 7.4 acre tract that was bought in 1987 for $400,000 and change. And our appraiser in that case, as it related to that property, said it was worth $6.2 million. Never been used for anything except industrial purposes. Steve Meadows, expert, said it's worth $1,200,000. And at the end of the day, we got $6.2 million for that 7.4 acres. It's on the banks of the Cumberland over there. The area in front of it is deep enough you could have a marina there. And we did all that before the Oracle deal was announced. And although that property is not part of the Oracle campus, it's just right behind there. So it's just amazing about how many assets that are involved in all this. So the Court of Appeals decided for us on the implied partnership issue, and that all of this is kind of simmering right now. The trial court had granted summary judgment with respect to that. The Court of Appeals didn't agree with that decision and sent it back to the trial court for trial. And so sometime this year, maybe if we can't settle it, we're going to try the implied partnership issue. And we're going to also figure out how to divide up the money from the joint sale of real property. So from a monetary standpoint, just to be honest, it's probably monetarily one of the biggest cases I've ever, been involved in. Nobody knows for certain. This is just more or less my speculation based on hopefully some factual things that are correct. But my guess is that given all the construction going on in Nashville, the value of Nashville Ready Mix is in the $100 million range. Yeah. And so it's going to be a big case. I mean, it's a case that I've been working on since 2016. And I mean, here I am. I think you said my birthday was February the 26th. And unless I misread the calendar, that means I've got another one coming around here pretty soon. And I'm going to be, 73 years old, and fortunately I'm in good enough health and stamina to keep on doing this practice, and I enjoy doing it. Can't imagine, not doing it. I mean, my family's I mentioned my youngest son, Rob, who's in law school. I have another son, Patrick, who's in Richmond, Virginia. He and his wife are up there. And so, by my reckoning, they're not in Nashville, they're pretty far away. And I need something to keep me busy. As long as I'm doing this, I might as well keep on doing it.
Well, as long as I've known you, you haven't changed a bit.
Well, thank you. That's fine.
I think you've got lots of room to carry on if you decide to.
Well, thank you. I'm going to still continue to try to do that.
Anything else?
Well, I think let's talk about Earl Hawkins just a minute if we can.
Okay,
that's
sure.
Not one of my reported decisions, but that's a big case. Earl was the criminal clerk here in Davidson County for a long time. He was a poor boy from East Tennessee, Hawkins County, who came to Nashville and got involved in local politics and got on the county patrol when I think Garner Robinson, I think, was the sheriff initially when he got off, and was and then got involved in politics and got elected, criminal court clerk, and at one time ran for mayor. Was unsuccessful in that effort, and pretty badly unsuccessful in that effort, but he nonetheless ran and had some support. Over the years, I mean, there's interesting little jousts in courthouse politics, and it turned out that for some reason, Tom Shriver, the district attorney, who's the best in the world, I like Tom, thought the world of Tom Shriver. Tom and Earl sort of got on each other's bad side. And Earl was more of an old-time politician. Tom was more sophisticated and you could argue more enlightened. And Earl sort of did things the old way. I mean, for example, people didn't think that parking tickets and speeding tickets were necessarily such bad things. Sometimes if the criminal court clerk could help intervene with the general sessions judge, those things could be dismissed. There wasn't any exchange of money or anything like that, but I'm sure it was believed that that would, enhance your standing as a political figure in town. And so Earl did those kinds of things. At some point, he had two divisions in his office: the General Sessions Division that was run by a guy named Joe Neely, and the Criminal Court Division that was run by a guy named Jimmy Shea. And those two guys couldn't have been any different. I mean, Jimmy Shea was the best guy that ever walked the face of the earth and did all the things that you'd ever want somebody you employed to do. And Neely, on the other hand, had his merits, I suppose, but he was kind of conniving and self-interested. Bill Farmer, in the trial of that case, called him, quote, lying, conniving weasel, and convinced Judge Morton that he should be able to argue that fact to the jury. And so Shriver, who was a diligent prosecutor, always suspected that cases were getting fixed by the criminal court clerk's office, or people in the criminal court clerk's office, in exchange for money. And so there was one General Sessions judge who perhaps was misguided in his effort, who used a signature stamp over there. And General Shriver believed that signature stamp was being used from time to time when it shouldn't be used. But he could never quite put his finger on it. And as we discussed earlier, he had tried a state commissioner of a department of Transportation or Highways, whatever it was called back in those days, Eddie Shaw, and had been defeated in that case by John Holland Sr. and Ed Yarbrough. And so he decided that he wasn't ever going to try public corruption cases much, if ever again, in the state courts. And so one of his former assistants and friends, Hal Hardin, was the United States Attorney, and he went over and started discussing what he perceived to be the shortcomings of the criminal court clerk's office with Hardin. And so then the FBI started investigating, and it involved surreptitious recordings and other things, informants. And at some point, and we'll all remember this, state TBI, FBI, well, not FBI, TBI, local police, and maybe some other law enforcement agencies, but not federal agencies, came in and padlocked the Davidson County Criminal Court Clerk's Office, and then executed a search warrant and searched all the desks and the big red books and all that stuff, and the computers and all that stuff. And they found a bunch of incriminating evidence. And so a grand jury investigation was commenced. Earl had been represented for many years by Mr. Jack Norman Sr. Mr. Norman had gotten much older. Against Mr. Norman's best instincts, when Earl got a subpoena to appear before the federal grand jury, he permitted him to go. And among many other things, he was asked by Hal initially whether he had ever said to one of his employees, I just wouldn't tell the SOB's S. And Earl said, Earl was really sort of a charming old guy. He said, I didn't know there was that many people over there. He said, I thought he was trying to embarrass me. And he said, I didn't remember ever saying that. And I said, oh, no, I would never say anything like that to one of my employees. Well, unfortunately for Earl, a woman named Judy Hooven, who was a clerk in his office, had a tape recording, or had a recording device on when Earl came into the office one morning and she said to him, "Earl, I've gotten a federal grand jury subpoena. What should I say?" Well, on the tape, you could hear Earl just gasp for breath. It just scared him. That fear turned to anger. And he said what I said he said. Well, and so then he was invited back to the grand jury again, asked the same question, gave the same answer by some perjury expert from the Department of Justice. And there's a statute, 18 U.S.C. 1623, which is part of the RICO statute, that says two statements in court, which are inconsistent with an out-of-court statement, is a basis for perjury counts. So counts of perjury on that, and an obstruction count. And then for the second or third time in the history of the United States, the United States Department of Justice approves a RICO indictment. And in the indictment, basically, it is alleged that the Davidson County Criminal Court Clerk's Office is a criminal enterprise within the meaning of RICO. So, brand new statute, not a lot of litigation about it in terms of parameters and so forth. I come into Willis's office in May of '79, and I kind of get immediately thrust into that case because I've got some criminal court background. So, as I said earlier, I'm kind of the case agent. I'm out. The indictment has two sets of people who have supposedly bribed the criminal court clerk's office or criminal court clerk officials to fix DUI cases, those in Davidson County and those in Cheatham County. And of course, the way the scheme was perpetuated was that the dockets in General Sessions Court for the disposition of DUI cases and everything else were set with computers. And so if you put in a trial date that the case was going to be heard in, January of 3000, the case is not going to come up for a while. And then you can, get rid of warrants and not write things in books and do all this stuff. And then there's an exchange of cash. That was the deal. The guy that the General Sessions judge who was suspected, but no proof was ever presented. And by the time that this investigation was occurring, had retired and moved to Florida, was never implicated in it. But his cohort, Joe Neely, who had been the head of the General Sessions section of the office, was a primary target of the investigation. Neely was represented by Sam Wallace Sr. Hal pretty quickly convinced Neely that he was in deep trouble and needed to make as good a deal as he could make as soon as he could and provide information to the government with respect to all of this. And frankly, from my perspective, Joe didn't get a very good deal. But in any event, he ultimately was the chief witness, and he implicated Earl Hawkins in that case. And Mr. Norman Sr., who I got the privilege to meet in the course of that case, brought Earl Hawkins over to Bill Willis to be represented. And so, we took over Earl's representation. Another person in the General Sessions Division was a guy named Dewey Durham, who was represented by Bill Farmer, the federal public defender at the time, and my good friend. And then another person in the General Sessions section, Bubba Smith, was represented by Joe Binkley Sr. In that. And then a bondsman was indicted named Jerry Hibden, who was represented by Pat Kennedy. And you had this titanic battle getting ready to occur. I went out at Willis. Of course, again, I was the brief writer and the case agent who went out to interview the witnesses. And the primary people that we wanted to represent, to interview, were the people who said that they had paid bribes to have DUI cases fixed. And there were a number of them in the indictment. And I interviewed every one of them and took their statement and basically asked them if they knew Earl Hawkins, if he had any contact with them, and if they'd given him any money and all that. All of them to a person, they said absolutely no. And nobody ever told them that Earl was involved in all that. And of course, I committed all that to the memoranda for the file and memoranda for the file. And then I worked with Mr. Hawkins to get his testimony prepared for trial. And that was a challenge because Mr. Hawkins was not the most articulate guy in the world. But he was a pretty good man. And so, again, it was a case involving a lot of pretrial publicity, which was very prejudicial. I mean, particularly the padlocking in the criminal clerk's office. All the media companies, for some reason, had been notified. I mentioned in my outline, and we'll get this in real quick. I mean, back in the older days, as we both know, the media was much more on site in the courthouse, and you had Kirk Loggins, who was a fine reporter for the Tennessean, Ham Gordon, who was a fine reporter for the Banner, down in an office in the basement of the courthouse, just pouring through everything. And so in any event, one of the things that I thought suggested the bill that we do is ask for individual voir dire in the case, because the idea being, of course, that you wouldn't want to have the veneer tainted by something that one of the members of the veneer had heard. So we filed the motion, not expecting the chief judge of the district court, Cora Morton, was the trial judge in the case. And we didn't think Judge Morton would, think very hard or long about that. Certainly would deny it, but to our great surprise, granted. It turned out that was a really important thing. And so Bill, being generous, allowed me to participate in the jury selection. And having gone to a Baptist school in East Tennessee, and grown up sort of in that culture and being from the South, I thought that Earl's statement to Judy Hooven would be, offensive to some people and could be very problematic. So one of the questions that I posed to prospective jurors individually on voir dire was whether if proof showed that our client, Mr. Hawkins, had said to one of his jurors, "Yes, I just wouldn't tell those SOBs S," could they give, as a result of any deeply held moral or religious belief, would they be unable to give him fair and impartial trial? Well, you can't believe it. I mean, people, oh no, I could never give a man like that fair and impartial trial. And to Judge Morton's credit, he didn't say, if I told you that wasn't legitimate and you needed to set that aside and base it on the facts and the law as I give it to you, would you be able to give him a fair and impartial trial? He didn't ask that question. And so the minute they said, "Oh, no, I couldn't do that," man, he would excuse them. And I have tremendous respect for Judge Morton about that. Because no matter what they said, they wouldn't have been able to give him a fair and impartial trial. And so we just kept on popping them like that. And the other lawyers were doing great on challenges for cause as well. And we picked a great jury in that case to juxtapose it with the jury we picked in the Blanton case. And so, of course, Judge Morton had been a former FBI agent, was a pretty conservative guy, liked the government side of the case a whole lot. And after it was over with, after jury selection was over with, he invited us back to the chambers. And back in those days, people smoked, including the judge. And he said, you know, the smoking lamp is lit. So Judge Morton's taking a big drag off a cigarette. Bill Willis is over with his pipe like this. Judge Morton says to Willis, he said, Mr. Willis, he said, you and your lawyers, these other lawyers have managed to pick 12 of the dumbest SOBs in the Middle District of Tennessee to be at this jury. And Willis does not miss a beat. He pulls that pipe out of his mouth and says, well, Your Honor, we believe our clients are entitled to a jury of their peers. And so we embark on this trial that just goes on forever. We started the first week or not the first week, but the second week, I think, of August of '79. And we tried it up until 2 weeks before Thanksgiving. So long trial. And just magnificent work by Willis in terms. Judy Hooven, I'm sitting over there watching him, and he says to Judy Hooven, among many other things on cross-examination, Ms. Hooven, did you ever tell Mr. Hawkins you were taking money to fix these DUI cases? And she says, no, I never did. And I'm thinking, oh, that's great. You need to stop right there. But then he goes ahead, daredevil that he is, and says, well, why didn't you do that? And she said, I thought she'd say it because I was afraid he'd make me split it with him. What she said was, I was afraid he would fire me. And, and then he takes Earl through it. And of course, Willis would lead a witness like a mule, and Morton was trying to slow him down on all that. But Earl made it through. And when it came to the perjury thing, I just thought it's going to be impossible to defeat that. But he just said, look, I just didn't remember. I honestly did not remember. And I believe that was truthful testimony. And the jurors agreed with both of us on that because they acquitted him of both counts of perjury, the obstruction count, and quitting everything else. And they hung with respect to one RICO count involving Judy and a conspiracy count. And then, as we said earlier today, ultimately, Mr. Hawkins resigned from office. Hal Hardin didn't prosecute him on the two counts the jury hung on. And ultimately, George Barrett convinced the Metro Council to reimburse Earl all of his legal fees. So that was the Hawkins case. And so that was, just a tremendous experience for me. I got all kinds. And the other factor in the case was Willis, he wanted to be sure that I had reported correctly about what the bribors had said. So when it came time to cross-examine the people who paid bribes, I got to do that examination. And I asked them the same questions that I'd asked them when I interviewed them. And they gave me the same answers. And the government made a tactical mistake about that. They called a lot of those people to testify. And every one of those people said never had a thing to do with Earl Hawkins as related to all of this. But again, between the jury selection and that repetitive testimony, and Judge Morton even gave some of our special requests for jury instruction. So he couldn't have been fair. He didn't like it, but he could not have been fair in terms of the way he conducted the trial of that case. He was really a remarkable guy. Yeah. So that's it. I think that pretty well covers the waterfront.
It's great. I think there's so much information here that law students are watching.
Well, it's been an interesting career, I'll have to say. Spent my life in an interesting one.
Yeah. And you told me why you came to Vanderbilt when nearly every other guy who wanted to go to law school, he went from East Tennessee, went to the University of Tennessee.
Yeah. Well, yeah. Yeah, that's right. Well, it was interesting.
Well, it's been a great career, Bob. I'm glad we got it on record.
Well, thank you, me. I am too. It'd be good for my boys and posterity.
Yeah.
I don't know if anybody else would be interested in looking at it, but they come down. I've drugged the boys to court with me over the years, all the time on the Delaney versus Thompson case. I had Patrick and Rob at various points and all of that.
Yeah.
And so, you know, exposed me to it.